and then everything will be live. So mute your mic after. And you can go ahead and share that graphic. And I'm going to jump out and we'll see if it stays working.
to their breakout room then?
Hi, good morning, everyone. Or good afternoon, I guess. If you want to have a pre-trial meeting, you can enter the tech room and that will be the place where y'all can all be together.
Excellent. I'm not sure if I can do that on my own. I think I have an earlier Zoom iteration. Could you add me to that room?
Absolutely no problem.
Thank you.
Hello, good afternoon, and welcome everyone to the final round of the South Texas Advocacy Tournament. So do I have everyone present? All right, we are ready to begin.
Good afternoon, everyone. Welcome to the final round of the South Texas Challenge for 2021. My name is Mike Barry. I am the president and dean of South Texas College of Law, Houston, and we are thrilled to have you join us for this final round, whether you are here on the Zoom or you are watching on YouTube. Congratulations to those who have made it to the final round. Very well done. We are thrilled to see you in the finals here today. This is the 10th anniversary of the South Texas Challenge, so we decided to do something just a little bit different this year. The judges who will be presiding over this final round, the scoring judges, are those individuals who have already competed here at South Texas and are champions from the past. So competitors, you will be appearing before those who have walked this very path that you have walked, who have appeared in the South Texas Challenge and who have prevailed. So let me take a moment real quickly and introduce you to those who will be your scoring judges for today. From the inaugural South Texas Challenge back in 2012, we have 4 individuals who represented Georgetown at the time. We have Erica Aiken, who is currently with WilmerHale in Washington, D.C., Christopher Rollins, who is currently general counsel at InfoTrack Systems in Orem, Utah, Kevin Homiak, who is at Homiak Law in Denver, Colorado, and Michael Burns, who is at Hogan's Level in Baltimore. They represent the 2012 championship team from Georgetown. Coming up next, we have those who were here in 2014 from Georgia, and specifically David Dove, who works at the Office of the Governor, Brian Kemp in Atlanta, and Maggie Randalls, who is at Chever Hamilton in Atlanta. Continuing the Georgia tradition in 2017 is the witness from the 2017 championship team, Lauren Lutton. Lauren came back in 2018 and was part of the championship team in 2018 as well. She is here as well as her partner at the time, Daniel Lockaby, who is currently with Sullivan Cromwell in New York City. And Lauren is at Jones Day in Atlanta. And the current reigning champions of the South Texas Mock Trial Challenge from American University Washington College of Law are Pernell Jackson and James Sullivan. Pernell is with the Philadelphia District Attorney's Office, and James Sullivan is at Latham & Watkins in New York City. We are thrilled to have these individuals coming back and representing their teams, their championship teams, and being the scoring judges for you. They join me as a scoring judge and our presiding judge. The presiding judge today is Ken Johnson. Ken Johnson is a graduate of South Texas College of Law and a former advocate himself. He is in private practice here in Houston, Texas, and has been on the board of directors for South Texas College of Law now for more than 20 years, serving as the chairman of our board of directors for the last 7. I will now turn it over to presiding judge Ken Johnson. Welcome, advocates. All the best to you in the competition this afternoon.
All right, do we have our teams present for the competition today? I do not see them.
Yes, Your Honor, defense is present.
Your Honor, plaintiff is present as well.
All right, very good. Let's do a little housekeeping before we get the jury in. So first, who represents the plaintiff? What is your team number?
It's EE, Your Honor. My name is Haley Carab, and I and my co-counsel Charles Hoffman represent the plaintiffs, Twyla Sands and Shannon Gibbs.
Understood. Ms. Carab, will you speak first?
Yes, Your Honor. Well, Your Honor, I'll be doing housekeeping. Mr. Hoffman will be handling motions in limine, and Mr. Hoffman will be opening.
All right, that's what I need then. So, Mr. Hoffman, would you spell his name for us, please? I consider him to be speaker one.
Yes, Your Honor. Last name is Hoffman.
All right. And what was the first name?
Charles, Charles.
Understood. And then I see your name on the screen. And you pronounced the last name Carab?
That's correct, Your Honor.
All right, if I mispronounce it, I apologize in advance.
That's all right.
All right, for the defense, what is your team number?
Good afternoon, Your Honor. Our team number is R.
R?
And yes, Your Honor.
And who will be the first speaker? In other words, who gives the opening statement?
Myself. My name
And
is
you're Miss
Bella.
Owen?
Yes, Your Honor.
All right, I see your name on the screen. And who is your teammate?
Today, I'm joined by my co-counsel, Rocky Moss.
If you'll spell that for us, please.
First name, Rocky, ROCKY. Last name, Moss, MAAS.
All right, very good. So as you know, I'm not Judge Scheit. Judge Scheit has had an emergency. My name is Johnson. You can call me Judge Johnson for this proceeding. So because of this change, I'm going to, we need to decide if you're going to allow this trial to go forward. I know the jury's already been picked. I know several things have already been covered in pretrial matters, but I do want to try to make sure we're all on the same page as this trial proceeds, and so that we reach a true and just outcome. In that regard, is there anyone that would oppose us having a record of this pretrial?
No, Your Honor.
No objection?
Honor.
All right. So we're on the record for purposes of pretrial, and then we'll have the jury brought in after we finish this, and then we'll start the trial. So I would like to proceed with pretrial in two steps. First, I would like to go over some things that I understand have occurred. I want to make sure we're on the same page. And the second part of that would be is if there's anything that's not covered, we'll finish up with that. So my understanding is that this is a daycare negligence case. My further understanding is that we have up to 10 witnesses that may testify in this trial in one way or another, and there are 8 exhibits that are in play. Am I accurate on that? What
That's
says the
accurate.
plaintiff?
Yes, Your Honor, that's accurate.
What says the defendant?
Yes, Your Honor, that's accurate.
All right, very good. Now, obviously, this is going to be a speed trial. I understand you've each got 70 minutes, a total of 140 minutes. We'll take a break at halftime after the plaintiff has rests. What do you normally do in these circumstances? A 10-minute break, a 15-minute break? How much time do you need?
Your Honor, 10 minutes would be great for the plaintiff.
Defense, what is your preference?
No preference, whatever Your Honor is amenable to.
All right, let's see how we're doing at the break. We'll do a minimum of 10. We might stretch it to 15, but we will agree on a time that we'll resume the trial after that. So when the jury comes in, what I plan to do is to read to them the first 5 points of the pretrial conference report. Do y'all have any problem with me doing that?
No objection, Your Honor.
All right. In that regard, I know that there is one defendant or 2 defendants that have settled out. That's going to be reported to the jury. That is one of the 5 points that I want to be on the up and up with the jury about. I presume that you will be able to deal with that in your opening statements and as you present your case. Is that going to present a problem for you?
Your Honor, the plaintiff would like to make a substantive motion in limine regarding the settlement with the Rose family. We can take
Right.
that up.
No, let's handle that. Let's, when we get to part B of pretrial, we'll do that, but don't let me forget, we want to cover that.
All right.
All right, fair enough. With regard to the 8 exhibits, have y'all reached an agreement as to admissibility?
We have reached an agreement as to admissibility for one of those exhibits, Your Honor, Exhibit
Oh.
S.
Say it again.
Exhibit S. Wobbly
Exhibit
Elms.
S.
Yes, Your Honor. It's Wobbly Elm's vaccination policy.
All right, so there's stipulation that S is admitted. Is that correct, plaintiff?
Yes, Your Honor, it is.
All right, well, we're going to pre-admit Exhibit S. What are we doing with the other 7? Are y'all going to lay predicates and try to get that admitted during trial, or where do we stand?
Your Honor, where we stand according to the plaintiff is we'll be laying the predicate for any additional evidence and handle that when it arises with the witnesses to be entering them.
Okay, defense, you agree?
Yes, Your Honor. And the defense intends to do the same.
Fair enough. All right, with regard to the remaining 7 pieces of evidence, are there specific evidentiary issues, problems, or challenges that I need to be aware of? Again, Judge Scheit and y'all may have covered this stuff. I'm a little behind. Is there something that I need to know about true evidence disputes on the remaining 7 exhibits?
Not at the outset, Your Honor. It will depend on the predicate laid in which witnesses they're entered on. We'd like to discuss that once it arises in trial.
All right, defense, how do you feel about that?
Exactly the same for the defense, Your Honor.
All right, fair enough. We'll keep moving then. So with regard to the 10 witnesses, this is the largest number of witnesses I remember seeing in this type of trial. I think it's going to be very interesting in how you get your evidence presented in the limited time that you have. But my understanding is that only 2 of the witnesses will be called live. So my questions with regard to your witnesses are, plaintiff, which 2 do you plan to call live?
Your Honor, the 2 witnesses the plaintiff will be calling live will be first, Twyla Sands.
Understood. Your second witness?
Second will be Dr. Stevie Budd.
Understood. All right. Defense, which 2 witnesses do you plan to call live?
Your Honor, the defense will call Pat Brewer and then Ronnie Lee.
Ronnie Lee?
Yes.
Understood. Are these witnesses ready and present?
They
Yes,
are,
Your
Your Honor.
All right, good enough. With regard to them sitting in the trial, what is your position with regard to Sands? Defense, do you have any objection to Ms. Sands sitting through the trial?
No objection to that, Your Honor.
All right, I wouldn't expect that you would, but I just
I
needed to ask.
apologize.
All right. And with regard to Stevie Budd, the expert, is that expert going to be with us through the trial?
Your Honor, the defense has no objection as he's an expert witness.
Or I understand that, but sitting in through the trial, are you going to object, or is there a basis for you to object to keep Mr. Budd? Is it Mr. Budd or Miss Budd?
Doctor, but he's a male.
Dr. Budd. Is there any reason to keep Dr. Budd out of the courtroom?
As he is an expert witness today, no, Your Honor.
Fair enough. All right, let's talk about the defense witnesses. Plaintiff, do you have any objection to Brewer being in the courtroom as we proceed?
No objection, Your Honor.
All right, and then what about, now is Lee an expert or is Lee a fact witness? What type of witness is Lee?
Mr. Lee will be a fact witness, Your Honor.
All right, so you're not going to be calling any expert witnesses live?
That's correct, Your Honor.
Got it. Okay, I understand that there has been some stipulation with regard to the settled defendants. How is that going to play out from the plaintiff's perspective today?
Your Honor, the plaintiffs will be making a substantive motion in limine to exclude evidence of the Rose family settlement under Federal Rule of Evidence 408.
All right. Anything else then that you're planning to do with regard to the Roses?
Yes, Your Honor. The plaintiff will also be making a motion when the case is called. The Rose family still remain on the caption of the case. We just will be asking that the caption be realigned to only include the remaining defendant, Wobbly Elm Daycare.
Well, that presents a problem on the charge then. How do you want the court to deal with that?
Your Honor, we won't be asking that any aspect of the verdict form be changed, but just for the purposes of clarity when the case is called, we just ask that the caption itself not list the Roses as an active defendant. We understand that the verdict form will and should still list the Rose family for terms of apportionment at the end of trial.
Defense, what do you say?
No objection, Your Honor. We stipulated to this before trial.
Okay, well, thanks. All right. Okay, is there anything else then in terms of the stipulations or the competition rules that we need to consider now with regard to Johnny Rose, or is it Moria? Is that how you say it?
It's
Moira
Moira, Your Honor.
It's what?
Moira.
Moira, I
Yeah.
can't even say it. Miss Rose. All right.
Sounds good.
Is there anything else that the court needs to be aware of with regard to these two settled defendants?
Nothing further from the plaintiff, Your Honor, with regards to Mr. and Mrs. Rose.
All right, got it. All right, on experts, sounds like we're only going to have one. My understanding is there are no Daubert challenges to this expert.
That's correct, Your Honor.
We're past all of that, right? Is the expert, I think you've already confirmed the expert is here, expert's ready to go, correct?
That's correct.
Very good. Okay. Now, in terms of evidence rulings, none of us want to embarrass ourselves in front of the jury today. So are there evidence squabbles that y'all are having that I should be aware of and be thinking about before we get to them during trial?
Not presently, Your Honor.
Okay, defense, what do you say?
Your Honor, the defense may be challenging some of the deposition testimony that the plaintiffs intend to admit, depending on which portions are admitted, at what time, and for what reason.
Okay, well, I will tell you my recent observations is that we're falling into some bad habits with speaking objections and talking to try to coach witnesses or influence the jury. So I have a question for you to see if you would be comfortable with this today. I would prefer, rather than you stating or explaining an objection, just to give me the rule. And if you give me the rule number, then I can make a ruling. And if I need more explanation, what we could do then is you could approach the bench and we could discuss the basis for the objection, the response to the objection, and then I could make a ruling. But I really want to try to keep this tight on the balls and strikes to make sure that both of you get a fair trial and the jury really understands this dispute so that they can make a proper and just decision. Are y'all comfortable proceeding that way?
That works for the plaintiff, Your Honor.
All right. What about the defense?
Yes, Your Honor, we're comfortable with that as well.
All right. Very good then. Let's try that. If for some reason we have trouble, we can revisit it, but let's plan on doing that. Now, with regard to the verdict form, I understand Judge Scheidt has already told you he drafted the form. We're going to follow the form. I know one or both of you may want to make a record on that. Are there any objections to the jury charge or the verdict form at this time that you want to put on the record?
No objections from the plaintiff.
What about
No.
the defense?
No objections from the defense.
All right. Well, then we're going to go with the form that we've got. And so in terms of whether you want to talk about that in opening, I don't have a problem with that. And certainly when it gets to close, I would have no problem with that. Do either of you have a problem referencing the verdict form in either opening or close?
No problem with that from the plaintiff, Your Honor.
What about the defense?
No problem with that, Your Honor.
All right, good enough. All right, we're to part B now. Are there other things that we need to cover in pretrial that we've not already discussed on the record?
Your Honor, we'd just like to ask a couple of your preferences.
Sure.
Throughout today's trial, may we assume that each witness has been pre-sworn, or would you like us to swear in each witness?
No, they've all been pre-sworn. I'll try to remind them of that when they hit the stand. But if for some reason I fail to do that, prompt me, we'll confirm. We want that point clear on the record, but yes, all witnesses have been pre-sworn for purposes of today's trial.
Okay.
What else?
And since today's proceedings will be on Zoom, would you like us to ask permission before we share our screen at any point?
You know, I'm comfortable with you just doing what you need to do. Defense, what's your preference?
Your Honor, once an exhibit has been admitted, our preference would be to be allowed to publish it on screen, but we're amenable to asking for your permission as well.
Well, I think let's try it this way. First, make sure that I have admitted your document, and we've only got one of 8 that's been admitted, and that's S, I recall. So anything else, you're going to have to lay the predicate. You're going to have to get it admitted before you could show it to the jury. And then at that point, you're free to do what you need to do with the exhibit. Okay?
Yes, Your Honor.
We're in agreement?
Yes, Your Honor. I do have a follow-up question.
All right.
When laying that predicate with witnesses that we are conversing with over Zoom, may we share our screen to lay that predicate as long as we ensure that it's constructively outside the presence of the jury?
If you will indicate that you're doing it constructively outside of the presence of the jury, I can't think of a better way to do that. Obviously, the witness must see the document in order to properly lay the predicate. So again, defense, do you have any problem with that protocol?
No, Your Honor.
All right, very good. Let's keep rolling. What else?
One final thing from the plaintiff, Your Honor. I'm going to share my screen with a calendar from October of 2019. That's the time at which the involved measles outbreak took place.
Understood.
We just asked the court to take judicial notice that this calendar accurately reflects the dates from October of 2019 as they were at the time.
All right, so what I understand you to be asking is for me to say, yeah, that looks like the calendar for October 2019. In other words, the 1st of October was the first Tuesday of the month. Is that what you're saying?
That's exactly right, Your Honor.
All right, defense, do you have a problem with that?
No objections, Your Honor.
Okay, you're good to go.
Yes, Your Honor, and no further housekeeping matters from the plaintiff.
Anything from the defense?
We have one further housekeeping matter. We just want to confirm that Your Honor has received an electronic notebook containing all of the exhibits. Is that correct?
I have, and I have printed them all. So I'm an old guy. I like paper. I have printed copies, albeit in black and white. Your technical data was very colorful and very small. So I also have my magnifying glass, but I think I'm ready in that regard. Anything else from the defense?
No, Your Honor. With that, we're ready to proceed.
Okay, so we talked about a break. And the only one we're anticipating is after the plaintiff rests, I'll entertain any motions that the defense may have at that time. But if there is an emergency or there is a need, all you need to do is to bring it to my attention. Fair enough?
Fair
Yes,
enough.
Your Honor.
All right, very good. Now, we are going to proceed under the federal rules of evidence today. True?
True. Yes, Your Honor.
True.
All right. And the local rules and the supplemental rules for virtual trials, I believe, have been stipulated to and will apply throughout this proceeding. Is that accurate?
Yes,
That's
Your Honor.
accurate, Your Honor.
All right. We're all in agreement on that, correct? I need
Correct.
verbal answers.
Yes, Your Honor.
Very good. All right. So I'm going to call for announcements. The court is calling the Sands and Gibbs case versus the Not a Real Company, Inc., DBA Wobbly Elm Daycare case to trial. Plaintiff, what is your announcement?
Your Honor, the plaintiff is ready to proceed to opening statements.
Very good. Defense, what is your announcement?
Your Honor, the defense is also ready to proceed to opening statements.
All right, I'm going to ask that the jury be brought in at this time and seated. Once they are seated, then I will do a little brief introduction and we'll start the trial. Please let me know when the jury is in the box. So bailiff, is the jury present now?
I will go ahead and check on that. Give me just 1 second. Jury's in the box, so you may proceed.
Very well. Ladies and gentlemen of the jury, welcome back to the courthouse. My name is Judge Johnson. You probably remember Judge Scheit from jury selection. He's had an emergency. He will not be here today. Judge Scheit asked me to preside over this trial so that we can get it handled and resolved. The council has agreed that I can serve as the presiding judge today. So we're going to proceed with the understanding that each of you are ready to carry out your sworn responsibility as jurors in this matter. As you probably recall from the jury selection process, this is a lawsuit to impose tort liability for actions related to the transmission of the measles virus at a daycare facility. Twyla Sands and Shannon Gibbs brought this suit individually and as the legal representatives of Catherine and Tennessee Gibbs to recover damages from Johnny and Moria Rose and the Wobbly Elm Daycare. The plaintiffs in this matter contend that the defendants were negligent in allowing the measles virus to be transmitted to their children and not taking steps to prevent the resulting measles outbreak. The defendants, on the other hand, generally deny each of the allegations made by the plaintiff. The plaintiff has settled their dispute with Johnny and Moria Rose. The only remaining claims are against Wobbly Elm Daycare. Now, something that has happened since we last visited, I need to inform you. The court has bifurcated this trial on the issues in this case. The liability of the phase of this case will be tried now, today. Any remaining procedures related to this case will occur at a later date. So, ladies and gentlemen of the jury, I just want to point out that this is a very serious matter. It's a very important matter to the parties, obviously, but it is also important to our community because what this case will reflect is how our community responds legally to these types of situations. And as citizens, we have two really, really important responsibilities. One is to vote as informed voters, and the second is to serve as jurors when called upon to fairly and dispassionately resolve legal disputes. We thank you for your service. Counsel is now ready to proceed. Plaintiff, do you wish to make an opening statement?
Yes, Your Honor, but briefly, may I approach?
You may approach.
Pursuant to our pretrial motions to exclude the evidence of the settlement and to remove the roses from the caption, now that the jury has been read those facts, may we ask for a limiting instruction after the trial that they disregard those details?
Well, I mean, you're going to be covering the fact that that there are settled defendants, aren't you, in your opening or in your presentation?
No, Your Honor, that wasn't our intention. But I can proceed into opening if this
Okay.
request is not to your
All right.
honor.
Well, normal course of conduct is tell the jury who's left, why there's a problem, and just go from there on your presentation. I'm sorry if I messed that up, but it's normal for me, at least in my court, to indicate who was sued, who's been resolved, and who remains.
Yes,
All
Your
right.
Honor. Apologies.
Very well. So are you ready to proceed with your opening statement?
Yes, Your Honor. Plaintiff is ready to proceed.
You may proceed.
May it please the court, opposing counsel, members of the jury, when you make a promise, you keep it. And if you break a promise, you tell someone. In October of 2019, there was a measles outbreak at a daycare here in Allister City. It happened because the defendant, the corporation that owns Wobbly Elm Daycare, made a promise, broke that promise, and didn't tell anyone. Now let's go back in time. It's February of 2019, and the plaintiffs, Shannon Gibbs and Twyla Sands, are looking for a daycare for their 3-month-old daughter, Kitty. Kitty is their second daughter, so while they tour facilities and meet with administrators, they can't help but think back to the last time they went through this process with their firstborn and how that ended. You see, their firstborn child, Tennessee, began her life as a normal child, but at 9 months old, Tennessee was diagnosed with liver cancer. That week, her parents, the plaintiffs, picked her up from daycare one last time and drove her to Mass General Hospital, where she spent the next several weeks. Tennessee eventually recovered from her cancer, but she was never able to return to daycare because to this day, she remains immunocompromised, and her doctors say it's not safe for her to receive certain vaccinations. So that's what Twyla Sands is thinking about while she researches daycares here in Alistair City for her youngest. Eventually, she finds one. It's pricey, but Kitty's safety and happiness are worth the extra shifts. So she calls them up. She makes an appointment for her and Shannon to come in. And when they arrive, they're greeted by the director, Pat Brewer. Pat Brewer delivers a charming sales pitch. So they walk the building from room to room, grinning at cubbies and tiny chairs. And then after the tour, Twyla gets to the point. She explains to Pat Brewer that their older daughter, Tennessee, is immunocompromised. And even though Tennessee won't be the one attending daycare, they're nervous about sending their younger daughter, Kitty. Kitty is still too young to receive certain vaccinations. And if she catches something at the daycare and brings it home, it could be devastating for both Kitty and Tennessee. Pat Brewer says, "Don't worry," hands them a copy of this. Twyla reads, "Wobbly Elm Daycare Vaccination Policy. Immunizations are required of all children attending Wobbly Elm Daycare. You must submit proof of the appropriate immunizations before your child can attend." She scans carefully down to the bottom. "We are not permitted to make exceptions." Now, Twyla Sands is all too familiar with keeping track of her children's medical records. There's a filing cabinet at home, overflowing with paperwork from Tennessee's various visits to the hospital. But reading this policy reassures her. These words, this policy, it's the policy of a dedicated, thorough daycare that takes the safety and security of the children in its care seriously. Kitty is going to be okay here, she thinks. So Twyla asks Pat Brewer if she can have a copy of the policy for her records. And Brewer says, of course. And the policy goes into that filing cabinet. And the next 8 months go by too fast until one Saturday afternoon in October, the plaintiffs decide to take their girls to the zoo. Even though she has to wear a mask, Tennessee loves the zoo. But this visit isn't fun because Kitty is fussy. She's sobbing and something is wrong. Twyla Sands picks up her baby girl and discovers she has a fever and calls their doctor. They find out soon after that it's the measles. As it turns out, an unvaccinated child named David Rose had been allowed to attend the daycare all year. The charming director knew the child was unvaccinated 5 months before the outbreak and said nothing. They made an exception for this child, David Rose, a family friend of the directors. And because of that exception, 11 children caught the measles. Kitty and Tennessee got it the worst. In that moment, Twyla Sands' heart sinks. It's all happening again. Again, she's standing in the hospital while her children fight for her life. This time, it's both her babies. So that's why you're here, members of the jury, to hold the daycare responsible for what they told parents one day and turned around and did the next. Because that policy you looked at, it wasn't just a policy, it was a promise. A promise this family relied on. A promise that convinced them to send Kitty to Wobbly Elm. And by not enforcing that policy, the daycare broke its promise. You'll hear today the daycare made unreasonable choices. Not only when they decided not to enforce their policy, not only when they decided not to warn parents that they'd abandoned their policy, but also when they let that same child, David Rose, come to the daycare with a fever, knowing he was unvaccinated and knowing he had a fever. When you make a promise, you tell someone. When you break a promise, you tell someone. Excuse me. When you make a promise, you keep it. When you break a promise, you tell someone. And when you know better, you do better. Now you're going to get to hear the story from Twyla herself. And after you hear from Twyla, Dr. Stevie Budd, who led the investigation into the measles outbreak, will come before you. Dr. Budd investigated the outbreak for the public health department. And Dr. Budd will explain exactly how the outbreak spread through the daycare and how this daycare violated its own policies. And then after you hear from the witnesses, after you look at the exhibits, the judge will come before you and explain, you have to make your decision by what's called a preponderance of the evidence. That means if you believe that the daycare's unreasonable choices more likely than not caused Kitty and Tennessee's harm, then find the defendant liable. And the judge will also explain that we as the plaintiffs have the burden of proof. So we have our own promise to keep. We have to show you that everything we say happened actually happened. Members of the jury, we intend to keep that promise. All we ask in return is that you listen, that you care, and then after the trial is over, my co-counsel Haley Carroll will come before you and ask that you return a verdict for the plaintiff and find the defendant, Wobbly Elm Daycare, liable in this case. Thank you.
Thank you, Mr. Hoffman. Does the defense wish to make an opening statement at this time, or do you want to reserve the opening until your case in chief?
Your Honor, the defense would like to make an opening statement at this time.
You may proceed.
They trusted the experts. It's a Tuesday afternoon in June, and Pat Brewer is dialing a number she's dialed before. The Department of Health and Public Safety. Eventually, she gets a live person. So here's the situation. I run a daycare. One of the parents is refusing to have her son vaccinated. Do I have to let the child stay? Do I tell the other parents? Am I allowed to tell the other parents? There's a pause on the other end of the line. And then the same answer Miss Brewer got the last time. Ma'am, can I get back to you on that? Members of the jury, the evidence will show that Wobbly Elm and its employees did everything they could to keep the children at their daycare safe. They tried to have a vaccination policy that balanced the children's health and their privacy. And when a situation presented itself that required real expertise they didn't have, they called the health department. But the evidence will show that every attempt to get guidance from the health department was met with silence. The evidence will show that Wobbly Elm did not cause this measles outbreak because their only mistake was trusting the experts. A moment ago, the plaintiff told you about Pat Brewer, director of Wobbly Elm Daycare. Now I want you to meet her. Ms. Brewer, would you turn on your camera for us? This is Pat Brewer. She's dedicated her career, her life to children, making sure they're happy, making sure they're healthy, making sure they're safe. Thank you, Ms. Brewer. Now, as the defense, we have no burden of proof. That burden lies with the plaintiff and the plaintiff alone. They have to prove every element of their case by a preponderance of the evidence, more likely than not. But today, 3 simple facts will leave the plaintiff unable to meet that burden. First, it requires professional expertise to understand this state's vaccination laws. Second, that's why Wobbly Elm consulted the experts. And third, Wobbly Elm did not cause the plaintiff's injuries. So let's take those one at a time. First, it takes professional expertise to understand this state's complicated vaccination laws. 2 years ago, Wobbly Elm sent a routine email to one of the families who attended their daycare. It said, "We need proof your son got his measles vaccine." But the email they got back was not routine, folks. No, we are not going to do that. We are claiming an exemption under state law. When Miss Brewer and Wobbly Elm got this response, they didn't know what to do. Because as you will learn, it's not exactly obvious what a daycare in that situation is supposed to do. You will hear there are no websites, no laws, no written guidelines that explain to businesses what they're allowed to do when an existing customer exercises their right not to get vaccinations. Just like you will hear, there are no websites, no laws, no written guidelines that tell businesses whether they're allowed to reveal private medical information belonging to some of their customers, if it might help some of their other customers. The evidence will show these were questions that required professional expertise. The second fact we will prove, Wobbly Elm tried to consult the experts. Ms. Brewer will tell you about her phone calls to the state health department, about her meeting with a local health department official. In fact, you will meet that local health department official today, Ronald Lee. He will admit that in 2019, Ms. Brewer came to him for advice about how to handle this situation. He will admit that he promised to get her answers. And he will admit that he never got back to her. The third fact we will prove today, Wobbly Elm did not cause the plaintiff's children to get measles. Now, it's true. Children at the daycare, they got sick. Some of them, like the plaintiff's older daughter, became very sick. And our heart goes out to those families and their children. But you will hear that it was the Rose family who refused to get their son vaccinated and who sent him to daycare when they knew he was sick. You will hear it was the health department who couldn't and didn't provide answers to Wobbly Elm's questions. Now, I want to be clear. We're not saying that Wobbly Elm had a perfect policy when it came to vaccinations. They said everyone had to have the required vaccines, no exceptions. But when one parent claimed a personal belief exemption under state law, they didn't know what to do. They didn't know how to protect one family's safety without compromising another family's privacy. So they turned to the experts. Or at least they tried to. Members of the jury, we know vaccination is a controversial topic these days. People have genuine differences in opinion. Some of you may have a difference in opinion. But this case, it's not about whether vaccines are good or bad. It's about whether a daycare is responsible for interpreting, deciphering this state's complicated vaccination laws. The evidence will show that this wasn't a problem a daycare was in a position to solve. At the end of this trial, we will ask that you find Wobbly Elm not liable, because all they did was trust the experts. Thank you.
Thank you, Ms. Owen. All right, we're ready for evidence. Plaintiff, are you ready to call your first witness?
Plaintiff is ready, Your Honor.
Who will you call?
At this time, the plaintiff calls Twyla Sands.
Ms. Sands, if you'll approach the bench or approach the witness chair, I remind you, you've been pre-sworn. Is there any reason that you can't proceed, Ms. Sands?
No.
You're ready to go. All right, Mr. Hoffman, you may proceed.
Could you introduce yourself to the jury?
My name is Twyla Sands.
And Ms. Sands, can you tell us a little bit about yourself?
Yes, I am 30 years old. I have been married to Shannon Gibbs for 7 years now. We have two beautiful daughters, Tennessee and Catherine. We call Catherine Kitty.
How old are Tennessee and Kitty?
Tennessee is 7 now, and Kitty is about 2.5.
Now, Ms. Sands, can you explain to the jury, why are we here today?
Back in October 2019, both of my daughters became very sick and were hospitalized because they both contracted the measles after our youngest, Kitty, was exposed to it at Wobbly Elm Daycare. She then infected my daughter, Tennessee.
At that time, were your children vaccinated for the measles virus?
No, Kitty was not even 1 at the time, so she was too young to receive the vaccine. Tennessee had a liver transplant and it caused her to be immunocompromised. And we were advised by our doctors that it wasn't safe for her to receive the measles vaccine until her immune system fully recovered.
You mentioned that the girls were hospitalized as a result of what happened. How long was Kitty in the hospital?
She was in the hospital for 2 weeks. We had to spend her first birthday in the hospital room.
How long was Tennessee in the hospital?
She was in the hospital for over a month. She was really touch and go for a while. We didn't even know if she was going to make it.
And have there been lasting effects?
Objection,
Tennessee-
Your Honor, under 401 relevance.
Overruled.
Ms. Sands, I'll ask my question once more. Were there lasting effects as a result of this incident?
Tennessee still has to go to the doctor every week. They have to follow up because we don't know what lasting effects she might have from the exposure. Kitty also has to be monitored. She could have serious brain injuries from getting the measles before the age of 1.
Now, you said that they got the measles from the daycare. Did Tennessee go to daycare?
No, she did not. Like I said, she was immunocompromised, and so it's not safe for her to go back to daycare yet.
Can you explain to us, how is it different to raise an immunocompromised child?
We have to be very careful about who and what Tennessee is exposed to. All the things that we do now because of COVID-19, we did in 2019 to protect our Tennessee.
What sort of things are you talking about?
Tennessee has to wear masks out in public. We really only take her to outdoor places like the zoo, where we can be socially distanced from others.
I see. And Kitty's not immunocompromised?
No, she's not.
So did Kitty go to the daycare?
She doesn't anymore, but yes, she did go to Wobbly Elm Daycare up until the outbreak.
How much did it cost to send Kitty to Wobbly Elm Daycare?
It costs $1,800 a month, which is a lot for us, but we thought it was important to send Kitty somewhere where that she would be well cared for.
And why did you choose Wobbly Elm in particular?
Pat Brewer assured us that it was going to be a safe environment for Kitty. Pat showed us the daycare's vaccination policy, and that policy made us believe that they took our children's health seriously.
Why was that vaccination policy important to your family?
Because of Tennessee, her being immunocompromised meant that we had to be careful and cautious of sending Kitty to daycare.
And you said Pat Brewer gave you that policy?
Objection, Your Honor, leading Rule 611C.
Overruled. Proceed.
Who gave you the policy, Ms. Sands?
Pat Brewer did.
And when was that?
Before we enrolled Kitty, we told Pat that Tennessee was immunocompromised. And so Pat gave us the copy of the policy. We looked at it. We believed it was strict, and we thought it meant they would take Kitty's safety pretty seriously.
Your Honor, at this time, plaintiff asked permission to share my screen with what's been previously admitted as Exhibit S, the policy in question.
Defense, you have any objection to that? Seems reasonable to me.
No objection, Your Honor.
You may proceed.
Okay. Ms. Sands, are you able to see the policy?
Yes.
What was it about this policy that specifically stuck out to you?
There were a few things. For instance, the first line, that immunizations were required of all children attending Wobbly Elm Daycare. The next line, that parents must submit proof of those immunizations before the child could attend. And towards the bottom, we are not permitted to make exceptions.
Okay, Ms. Sands, I'm going to stop sharing and just return to you. What did it mean when the daycare handed you this policy? What did it mean to your family?
To us, this policy was a promise to protect Kitty from things like the measles. This policy is why we entrusted them to care for our child. We thought they required parents to immunize their children.
Did you rely on this policy then?
Absolutely. If the daycare had just told us they weren't enforcing the policy, or that the policy had changed, we would have avoided all of this because we would have pulled Kitty out immediately.
When did you find out the daycare wasn't enforcing the policy?
The daycare never even told us. We only learned after the outbreak. We found out that a child named David Rose was allowed to continue going to the daycare all year without any vaccinations, after the health department did an investigation.
Before the outbreak in October 2019, did anyone from the daycare share with you that the policy wasn't being enforced with regard to David Rose or any child at the daycare?
No, the daycare never told us anything about making an exception for David Rose, that their policy had changed, or that they were studying it or anything. We were completely left in the dark, and had we known, we never would have been there for Kitty to get it. It feels like they promised to look after our baby, and they broke their promise and then kept it a secret from us.
And at the time that this outbreak actually happened, what did you understand Wobbly Elm's vaccination policy to be?
All that we had was the sheet of paper that Pat Brewer gave us. The policy said no exceptions.
Okay, Ms. Sands, I want to return you to Kitty in Tennessee. How was it that you first discovered they had the measles?
It was a Saturday, October 19th. We had taken the girls to the zoo for the day, but Kitty was really fussy and she had a fever, so we went home. We immediately called the doctor. They couldn't see Kitty until Monday and told us to separate the girls over the weekend, so we did. We drove them both separately up to the doctor on Monday, but it was too late.
That was Monday, October 21st?
Yes.
And what happened at that doctor's appointment?
By Monday, Kitty already had spots in her mouth. She had the beginnings of a rash going down her body. Kitty was diagnosed with measles that day, and both Kitty and Tennessee were admitted to the hospital that same day.
Did you inform the daycare that Kitty had been diagnosed with measles?
Of course, we called the daycare that day that Kitty was diagnosed.
Why?
Because we were worried about other children, that they might be in danger too. The way I was raised, that when you find out something's wrong and that someone might be in danger, you speak up, especially when there's babies involved.
Thank you. Pass the witness, Your Honor.
Cross-examination.
Yes, Your Honor.
You may proceed, Ms. Owen.
Good afternoon, Ms. Sands. Can you
Good
see and hear
afternoon.
me okay?
Yes, I can.
Excellent. So I just want to make something clear. On direct examination, you said that you told Pat Brewer your daughter Tennessee was immunocompromised. Is that right?
Yes, that's correct.
And that's your testimony today.
Yes, that's correct.
Ms. Sands, this isn't the first time you've testified in this case, is it?
No,
You were deposed.
that's correct.
in that deposition, you took an oath.
That's correct.
The same oath you took today to tell the truth.
Yes.
Ms. Sands, if I could direct your attention to your electronic notebook, to the transcript of your deposition testimony. It's Exhibit E, specifically Exhibit E10 through E11. Please let me know when you have it in front of you.
One moment. I'll have to pull that up. I apologize. This is
No worries, Ms. Sands. Just let us know when you're there. Ms. Sands, would it help if we constructively shared the transcript of your deposition testimony outside of the view of the jury?
yes, it would. I'm not seeming to be able to pull this up.
That would help the judge. All right, we're constructively viewing outside the presence of the jury the sworn testimony.
Yes, Your Honor.
All
Ms.
right,
Sands, this is the transcript of your deposition testimony, right?
Yes, that's correct.
It's a fair and accurate copy.
Yes, that's correct.
So I'd like for you to just silently read to yourself while I read your testimony out loud. It's towards the bottom for the court. Question: do you know if the daycare knew Kitty was unvaccinated? Answer: they did because I told them. Question: what do you mean by both of these things? Answer: the fact that Kitty and Tennessee were unvaccinated. Now, Ms. Sands, nowhere else in this deposition testimony did you mention that you told Pat Brewer Tennessee was immunocompromised.
Yes, it's nowhere there. I agree with that.
Nowhere at all.
Yes, from what I was deposed on, yes, it's not there.
So just to be clear, today is the first time you're saying you told Pat Brewer she knew your daughter was immunocompromised.
Sure, I guess. I mean, I believed I'd told her, but I guess it wasn't deposed on, so it's not there.
So that's a yes. It's not in your deposition testimony.
It is not in my deposition testimony. That is correct.
Thank you, Ms. Sands. You can close your electronic notebook. So I'd like to talk about who decides whether children are unvaccinated. You have two daughters, right, Ms. Sands?
Yes, I do.
Your older daughter is Tennessee.
Yes.
She's 6 years old.
Yes.
Now, Tennessee has never been vaccinated for the measles. Is that right?
No, she has not. Her doctors advised against it.
That's right. It was the doctor's recommendation that she not be vaccinated for the measles. Yes?
Yes. Yes.
And it was your decision.
Yes, it was our decision to listen to the advice of our doctors. That's correct.
So what you're saying is you trusted the doctor to know what vaccination your child needed.
for our daughter who they had cared for, who had gone through chemotherapy. And yes, we trusted them. They're overly cautious, and of course.
Ma'am, you trusted the expert, right?
Yes, we trusted our doctor who had been caring for both our daughters, of course.
Your younger daughter, her name is Catherine, right?
Yes.
You call her Kitty.
Hmm.
Now, Kitty's about 2 years old, isn't she?
Yes, about 2.5 now.
She didn't get the measles vaccine before her first birthday, did she?
It's correct. She was too young for it. And
She got the measles vaccine after she turned 15 months old, right?
yes, that's correct.
That was the doctor's recommendation.
Yes, that was, yeah, doctors, CDC, yes.
Now let's talk about Wobbly Elm's vaccination policy. Kitty started going to Wobbly Elm around the end of 2018, right?
Yes, that's correct.
That was before she got the measles vaccine, wasn't it?
Yes, she'd been attending there before she had that, before she was old enough, correct.
So Wobbly Elm allowed Kitty to start attending the daycare before she got her measles vaccine.
That is correct. They base their policy on CDC schedule per the policy.
So that's a yes to my question. Wobbly Elm allowed Kitty to start attending the daycare before she got her measles vaccine.
Yes, by following CDC guidelines, that's what they did.
Now, by October 2019, Kitty had been going to Wobbly Elm for about 9 months.
Yes,
She still hadn't received her measles vaccination, had she?
no, she was still not even a year old, so she was under the age requirement.
And Wobbly Elm never kicked her out.
No, she was not in breach of the policy.
So that's a yes to my question. Wobbly Elm never kicked Kitty out.
Not for not having the measles vaccine before she was old enough. That's correct.
So let's talk about what you knew when you signed Kitty up for daycare. You knew that there would be other children at the daycare, didn't you?
Of course, it was a plus for us.
You knew that Kitty would be interacting with these other children.
Yes, that was one of the big things we wanted her to be able to do.
Exactly. You knew that Kitty would even be sharing the same physical space as these other children.
Of course, yes.
Now, when Kitty joined the daycare, she was in the newborn class. Is that correct?
That is correct, yes.
You knew the other children in the newborn class, they were less than 6 months old, right?
Yes,
So you knew that some of these other children, they might not be vaccinated for the measles.
yes, I knew they would not be vaccinated for the measles.
You knew Kitty could be interacting with other children who weren't vaccinated for the measles.
Yes, because they were all too young to receive the virus and it work effectively, yes.
And you allowed Kitty to attend Wobbly Elm Daycare, didn't you?
Yes, we did.
Now, after Kitty turned 6 months old, she got moved to a different class. Is that right?
Yes,
With a different group of children.
yes, 6 to 12 months.
That's right. And at this point, Kitty still hadn't been vaccinated.
Right, she had still not turned the age appropriate to receive the measles vaccine.
So you knew that some of these other children in this same age group, they might not be vaccinated for the measles either.
Objection asked and answered.
Sustained. Move along, counsel.
Now, Ms. Sands, you didn't ask for these other children's vaccination records, did you?
No, of course not.
And you allowed Kitty to continue attending Wobbly Elm Daycare?
Under the guise that the policy we were given was being enforced, yes, of course.
So that's a yes to my question. Ms. Sands, you allowed Kitty to continue attending Wobbly Elm Daycare with that knowledge.
With the knowledge, can you repeat, with what knowledge?
Of course, Ms. Sands, my apologies. With the knowledge that Kitty might be interacting with other children who weren't vaccinated for the measles, you allowed her to continue attending Wobbly Elm Daycare.
Objection asked and answered.
I'm going to let Ms. Owen make her point. Please finish up, though. You're getting close here.
Yes, Your Honor.
Yes, I knew because of the age groups and the setup of the daycare that yes, she would be around other children in her class because they were not of age yet.
Thank you, Ms. Sands. Pass the witness.
All right. Any redirect, Mr. Hoffman?
Briefly, Your Honor.
Proceed.
On cross-examination, Ms. Sands, you talked about the other children in Kitty's class. Are you familiar with the CDC guidelines? For vaccines?
Yes, fairly. No expert, but
So when a child is 6 months old, do they have any vaccinations?
of course, I'm not sure of the exact number, but there are a certain number of vaccines that children get in stages as they grow older. But you don't get them all at once. I know that.
So when Kitty was in the 6-month to 12-month class, did you anticipate that she would be in school with any children who had received no vaccinations?
No, of course not. Based on the policy that said that the daycare was going by CDC schedule, absolutely not. I believed that they would have had the age appropriate vaccines.
And why did you send Kitty to daycare?
When we had our second kid, we were scared after what happened with Tennessee. And when Kitty was born, Shannon and I promised each other that we were going to treat her like a normal kid despite our paranoia and panic. We sent her to daycare to fulfill that promise and to give her a happy, normal life.
Thank you. Your Honor, we just asked that Ms. Sands be permitted to be excused.
All right. She's going to stay for the trial, though, right? We're going to let her off the stand. We're done with her now, but she's not leaving. True?
Correct, Your Honor.
All right, good, because I don't want her leaving.
Appreciate
All
that.
right. Do you have a second witness to call?
Yes, Your Honor. Pursuant to stipulation 14, any witness that is not called live is technically unavailable for the rules of evidence. So at this time, the plaintiff would like to call by deposition testimony Sebastian Rain.
All right, how are you going to do that?
I can share my screen with highlighted portions constructively outside the presence of the jury if that's the best way that Your Honor finds it to be, because then I can read along with you and you can see what I'm reading it.
No, so what I'm interested in, you want the jury to hear this, don't you? You want the jury to see this?
Your Honor, I would like to share it with the jury, but if it can only be read in, then we're fine with just reading it in. Does the defense, I guess, if they object, we will cover it.
Well, all right. So we're at the bench now. Let's talk about this. Obviously, if it's not read, you're going to have a problem with the jury hearing it or understanding it when it's time to close.
Understood.
So I don't know if you're wanting to read hundreds of pages of testimony or just a few pages of testimony, but I'll do it any way you want. Y'all have agreed to it. You've stipulated to it. I'll take it where you read it. Between counsel, you can read it into the record if you want, Q&A, or if you just want to tell me we want page whatever, line whatever admitted, I'll take it that way. Your call.
Your Honor, I think what would be best is that we constructively share our screen outside the presence of the jury to field objections. During meet and confer, defense said that they did have potential objections. So we don't want to just bring this in because it hasn't been stipulated to, and we don't think that would be right. So we'd like to share this. And then after we've gone through our objections with you, then we would just have the portions that made it in after those objections be constructively read to the jury, if that makes sense.
Okay, we should have covered this in pretrial. I'm sorry for not pushing on this issue, but what we're going to do is we're going to give the jury a break. We're going to go through this now. And then once we resolve any disputes, any objections, we'll come back, bring the jury back, and then I'll let you present the evidence to the jury. Does that sound fair?
Yes, Your Honor.
All right, I see a nodding of Mr. Moss's head, so I think he's in agreement. Okay, very good then. All right, so ladies and gentlemen, the jury, we're going to excuse you for a few moments. Counsel and I have got a little work to do. Thank you. You're now out of the room. All right, Mr. Hoffman, show me, and Mr. Moss, what it is that you want to present to the jury.
Your Honor, are you seeing my screen?
Yes, and so be careful for the record, which deposition is this, what page? I don't see the lines on the transcript, but tell me what we're dealing with here.
Sure, Your Honor. This is the deposition testimony of Sebastian Rain, a former employee of the defendant Wobbly Elm Daycare. This is his deposition has been previously marked Exhibit H. This is page 3, also known as H3. The lines are not enumerated in this copy, so I will just be going by page number.
That's fine. I understand. So, Mr. Moss, I presume this is your witness. So do you have any objections to any of the Q&A on page 3 of Exhibit H?
Yes, Your Honor. Defense objects to inadmissible character evidence under Rule 404 for the lines from "and they were sent home" onward.
And your response, Mr. Hoffman?
Yes, Your Honor. I'd be permitted to scroll onto the next page to give some context for this conversation.
Sure.
So this conversation is relevant not as 404 evidence, but to demonstrate the defendant daycare's specific treatment of the parties at issue. The employee is testifying to the way that the policy was enforced, specifically with regard to the Roses and with the Gibbs family. And we ask that it's the plaintiff's contention that that's not 404 evidence, that it's specifically relevant to this transaction at issue.
I'm inclined to agree, but Mr. Moss, I'll hear what else you've got to say on the point with that clarification from Mr. Hoffman.
Yes, Your Honor, that clarification is exactly 404 evidence. They're using evidence of what the daycare did previously with other children to prove what they did in this instance with the Rose family. That's character propensity evidence. It's inadmissible.
Well, I disagree. I'm going to admit it. So your record is made. What else do you have, Mr. Hoffman?
Your Honor, that's it from this witness. We would like to also call another witness by deposition testimony, which my co-counsel will cover.
Yeah, but let's do it all right now while we got the jury out. So let me see the other testimony, and if it's Mr. Moss or Miss Owen that's going to handle it, they can respond. So what else do you have here?
Yes, Your Honor. I'm going to let my co-counsel share her screen.
Understood.
Yes, Your Honor, I'm sharing my screen now with the deposition of Moira Rose, David Rose's mother, and I'll be starting on page J13 once it's shared.
Okay.
Can you see that all right?
Yes.
So from page J13, this question and answer, you knew your children weren't vaccinated for anything, right? Answer, yes, of course, is all from this page. If there's no objections, I can continue to the next view.
Mr. Moss, is this your witness or Miss Owens?
This is my witness, Your Honor, and defense objects under Rule 401, 403, and 404.
And your response, Ms. Carob?
Yes, Your Honor, with regards to 401, this is relevant because it shows that David Rose was not only unvaccinated against the measles, but had received no vaccinations whatsoever. With regard to 404, there is no prejudicial effect to this because it demonstrates that this child is in direct violation of Wobbly Elm Daycare's policy, Exhibit S. And with regards to 404, this shows no propensity evidence. Again, it only shows the daycare's awareness of a policy violation.
Agreed. I'll overrule the objection. Mr. Moss, your record is made. What else do you have?
Your Honor, moving on to J14, would you like me to read these out loud or just allow you and opposing counsel?
No, just we can see it. Mr. Moss can see it. So tell me just in summary what it is you're offering here, and I'll hear Mr. Moss's objection if he has any.
Yes, Your Honor, this portion of deposition testimony shows that Moira Rose did in fact inform the daycare about David Rose being unvaccinated.
Okay, Mr. Moss, do you have any objections?
Defense has no objection to this portion, Your Honor.
Okay, fair enough. Let's move to the next thing.
Your Honor, this is now on J15. This portion deals with the defendant daycare's response to Moira Rose informing them that David Rose would not be vaccinated.
Mr. Moss, any objection?
No objection.
It's admitted. Let's go.
Your Honor, this portion of testimony on J16 shows that David Rose was allowed to attend daycare with a fever.
Okay, Mr. Moss, any objection?
No objection.
All right, it'll be admitted when it's read into the record.
And finally, Your Honor, this portion J17 shows Moira Rose identifying Exhibit Q, which is the email exchange discussed in the previous highlighted portion that defense raised no objection to. We will be offering this into evidence based on this identification and based on stipulation 17, which establishes that Exhibit Q is authentic and original.
So in essence, you're laying your predicate on Q at this time. Is that right?
That's exactly right, Your Honor.
Mr. Moss, what's your position?
Your Honor, we have no objection to this testimony, and we further have no objection to the admission of Exhibit Q.
Wow, good. We've got 2 exhibits in the record now. Very good, counsel. All right, so good. Well, let's move on.
And Your Honor, that's all from this deposition.
Okay, what other plaintiff depositions do you intend to present today? Because I want to get all of this covered before we bring the jury back.
Your Honor, that's all from the plaintiff in terms of deposition testimony.
All right, so Mr. Moss, does the defense have some testimony? I mean, would it make sense to do this now, or do you prefer to do it when you're in the middle of your presentation?
Your Honor, at this point, the defense does not intend to offer any deposition testimony. If any deposition testimony does become relevant, we'd prefer to do that during our case in chief.
Okay, fair enough. Sounds like a plan. Appreciate it. All right, so you can step back. We'll bring the jury in. Ladies and gentlemen, we appreciate your patience. We had a little business to take care of. Counsel is now ready to proceed.
Your Honor, at this time, plaintiff calls Sebastian Rain by deposition testimony.
Understood. You may proceed. Obviously, the witness has been sworn. He was sworn at the time of his deposition. He remains under oath for purposes of presenting this evidence.
Your Honor, is the jury able to see my screen?
I believe that they are.
I'm going to read this aloud by myself. Question: are you familiar with Wobbly Elm's vaccination policy? Answer: yes. Question: was there a general health policy? Answer: yes. Question: what was that? Answer: for the health and safety of all at the daycare, children and staff with a fever or who are otherwise sick are expected to stay home. If they get a fever during the day, they are supposed to be sent home. They shouldn't come back until they are fever-free for 24 hours. Question: and were they sent home? Answer: not always. Question: what do you mean? Answer: the decision to send a kid home was made depending on who it was. Question: when the kid was sick? Answer: yes. Question: who didn't send the sick kids home? Answer: Pat. I always did, but sometimes I would get overruled. Question: why? Answer: Pat did not want to inconvenience parents, so sometimes children were taken to an office with a cot to spend the rest of the school day. Question: and you say this depended on who the parents were? Answer: absolutely. No athlete's kid would be sent home. No country club kid would be sent home. It was all about the money. Question: did the Roses fall into that category? Answer: in Pat's view, they did. And with that, Your Honor, we would like for this witness to be excused.
Any objection, Mr. Moss, or any cross-examination?
No objection or cross-examination, Your Honor.
All right, we're done with this witness. What else do you have, plaintiff?
And Your Honor, at this time, I'm going to pass to my co-counsel.
She may proceed.
And Your Honor, at this time, the plaintiff will be calling by deposition testimony Moira Rose.
All right, you may call the witness by presenting the previously sworn deposition testimony. You may present it in any way that you see appropriate.
Yes, Your Honor. Starting on page J13 from the deposition of Moira Rose, David Rose's mother. Question: you knew your children weren't vaccinated for anything, right? Answer: of course I did. Moving on to J14. Question: did the people at daycare know David was not vaccinated? Answer: yes. Question: how did they know? Answer: I told them. Question: when? Answer: when he turned 15 months old. They wanted a copy of his updated vaccination records when he turned 15 months old. I told them he would not be getting vaccinations because I was claiming a personal belief exemption under state law. By the way, I also have a religious objection to vaccinations. Question: what did the daycare say? Answer: they said they would study the situation. Question: did they ever come back to you? Moving on to J15. Answer: no. Question: and when did the conversation occur? Answer: sometime in April of 2019. Question: did you ever send a letter to the state regarding your personal beliefs? Answer: no, I sent the email to Pat. Question: did you file an affidavit with the state? Answer: no, I sent the email to Pat. Moving on to J16. Question: did you continue sending David to daycare? Answer: yes, until the rash showed up. Question: when was that? Answer: I think the 19th. Question: did David have a fever at that point? Answer: a bit of one. We told the daycare to watch out for it. Your Honor, at this time, I'd like for a moment to publish Exhibit Q to the members of the jury, which has been previously admitted.
Correct. Exhibit Q is admitted for all purposes at trial.
Your Honor, that concludes the portions that will be entering from Moira Rose's deposition, and barring any objections or cross-examination, we ask you be excused.
Mr. Moss, is there any cross-examination, any Q&A that you want to read from either of those depositions?
No, Your Honor, nothing further from the defense.
Okay, very good. Then I guess we're done with the depositions. Are there any other witnesses that the plaintiff wishes to call at trial?
Yes, Your Honor, the plaintiff calls Dr. Stevie Budd.
All right, Dr. Budd, if you'd approach the witness stand. Remind you that you have been pre-sworn.
Yes,
You
Your
may
Honor.
proceed.
Good afternoon. Could you introduce yourself to the members of the jury?
Hello, my name is Stevie Budd. I'm the former director of public health here in Alastair City, and I now work as a public health consultant.
Can you explain to us what the director of public health does?
Yes, so in a broad sense, my job was to protect the health and safety of everyone here in South Texas. We would oversee all of the local health departments.
And could you tell us a little bit about your educational background?
Well, I received my undergraduate degree from the University of Chicago, and then I got my PhD in public health from Northwestern University.
Dr. Budd, how long were you the director of public health here in Alastair City?
For about 5 years, I left recently to run for lieutenant governor.
Were you serving as the director of public health during the measles outbreak here in Alastair City?
Yes, I actually led that investigation.
And when did that outbreak occur?
In October of 2019.
Dr. Budd, let's talk a little bit about the measles virus itself. Could you explain to us a little bit about what it is?
Yes, the measles is a highly contagious viral disease, and it can cause a lot of flu-like symptoms, but it's also accompanied by a rash. You can think you have the flu, but it turns out you actually have the measles.
Is this a dangerous virus?
Yes, it's incredibly dangerous. It's so dangerous because you can be infectious before you even know that you're sick. You can unknowingly spread the virus to people before you even have any symptoms.
How contagious is the measles?
It's very contagious. The virus can live up in the air for up to 2 hours after the infected person coughs or sneezes. The infected person doesn't even need to be in the same room for the virus to be transmitted.
And what are the symptoms of the measles?
There's a variety of symptoms. The measles can cause a fever, a cough, runny nose, watery eyes, and the measles can also lead to more serious problems like brain swelling and even death.
When might someone that has the measles start to show those symptoms?
They show symptoms about 4 days before the rash starts. In the medical community, we call that the prodrome period.
Is there a childhood vaccination that immunizes children from getting the measles?
Yes, there is. It's called the MMR vaccine. It also is a vaccine for the mumps and rubella. Well, the MMR vaccine is given in 2 doses or shots, once to children when they're 12 to 15 months, and again when they're 4 to 6 years old.
Why might it be important to get the measles vaccine?
Well, thanks to the vaccine, the measles has been considered eliminated in the United States since 2000. But the vaccine isn't a cure. It's just a preventative measure, and it just protects us from being able to contract the measles or spread it to others.
Would you recommend that places like daycares have policies for vaccinations?
Yes, absolutely. The measles is only considered eradicated because people have been vaccinated.
Are you aware of whether or not Wobbly Elm Daycare had a vaccination policy?
Yes, as I understand it, Wobbly Elm Daycare had a policy, a promise, if you will, that parents and the students at Wobbly Elm Daycare would follow the CDC's recommendation and their timelines for vaccinations.
And are you familiar with the CDC timelines that the defendant daycare's policy was based on?
Yes, I am.
So could you tell us, following that timeline, how many vaccinations would, say, a 1-year-old need to attend Wobbly Elm Daycare?
According to the CDC, a 1-year-old would need 6 different types of vaccinations.
To your knowledge, did David Rose have any of those 6 vaccinations?
Objection, Your Honor, under 401.
Approach constructively. What's the response, Ms. Carab?
The response, Your Honor, is that David Rose being eligible for 6 different types of vaccinations shows 6 different instances when the Wobbly Elm Daycare's policy was violated with regard to the students' vaccinations.
Yeah, it's relevant. Overruled. You can proceed.
Dr. Budd, to your knowledge, did David Rose have any of those 6 vaccinations?
No, he had not received a single vaccination.
At the time of the outbreak at Wobbly Elm, could David Rose have gotten the measles vaccine specifically?
Yes, David Rose could have received the MMR vaccine as early as 12 months old.
Dr. Budd, let's talk a little bit more about your time as the Director of Public Health. Did you investigate this outbreak?
Yes, I did. Me and my team, we spent 4 days there, and we discovered that patient 0 was a man named Ted Mullins. He was someone that had gone to Samoa during an ongoing epidemic over there in Samoa.
And how did you identify Ted Mullins as patient 0?
Well, everyone here in South Texas that contracted the measles, they could all be traced to him. He was the uncle of a child at Wobbly Elm Daycare, and the daycare became the epicenter of the initial spread of the virus.
Now, how is this measles virus actually traced to Ted Mullins?
Well, we were able to identify the specific type, the specific strain of the measles. It's not a common one. We canvassed the area. We met with doctors and the families of those that were infected.
So then how did the measles go from Ted Mullins to Wobbly Elm Daycare?
So after patient 0, this Ted Mullins came back from Samoa. Well, he was already sick. He had a headache, a cough, runny nose, watery eyes, but he still stayed and went with his sister. And then Ted exposed his nephew.
And who is his nephew?
That would be David Rose. He was the unvaccinated child that took the measles virus to the daycare and then exposed all the children there. Many of the children at that daycare were unvaccinated to the measles because they were too young.
So how did the measles spread once it got to Wobbly Elm Daycare?
Well, apparently the children were all in the same vicinity, even though they were in different classes. There was a common area at Wobbly Elm, so the measles was able to be transmitted from one child to another in that common area. Wobbly Elm Daycare also had a central air filtration system, so even though the children were in separate rooms, the virus could be spread throughout the building.
Dr. Budd, in your investigation, were you able to determine how Kitty Gibbs, the plaintiff's daughter, contracted the measles?
Yes, I was.
So could you walk us through how she got the measles then?
Yes, I can. And I've also brought a calendar along with me if it would help me explain how the measles spread.
Your Honor, permission for Dr. Budd to share his screen for the purposes of a demonstrative. He will be marking on the calendar we showed to Your Honor earlier today.
Yeah, I have no problem, but I want to ask Mr. Moss if he has any concerns about this.
Your Honor, at this point, we have no concerns just so long as the markings on the calendar come directly from the testimony.
All right, fair enough. You may proceed, Ms. Carab. We'll see if there's any problems that arise.
Of course, Your Honor. Dr. Budd, you can go ahead and share your screen.
Sure, one moment. I just want to make sure, can you all see my screen?
Yes, Dr. Budd, thank you. So let's start with David Rose. When was David's case of the measles able to be identified?
Well, David's rash first appeared on October 19th. I can mark that with a red star on this calendar.
So based on when David Rose's case of the measles was identified, when did David Rose actually become infectious or able to expose other people?
So when you have a rash, you can be infectious up to 8 days before that rash starts. So since David's rash first appeared on the 19th, up to 8 days would mean that he was infectious starting on the 11th. And I can shade all of those dates in red.
So based on the information that you reviewed, was David Rose showing signs of being sick around this time in October?
Yes, based on the information I reviewed, David Rose was allowed to attend the daycare prior to the outbreak after he had already developed a fever.
So let's talk about Kitty Gibbs then. When was her case of the measles able to be identified?
Well, she first had a rash on October 21st. Since she's a different person, I'll go ahead and mark that with a blue star.
So based on when Kitty Gibbs's rash appeared, when could she have been first exposed to the measles?
Well, based on how long someone incubates the measles for, 7 to 18 days, and based on when Kitty was actually at Wobbly Elm Daycare, Kitty was likely exposed on either 2 dates, and I can mark them. The first date is October 11th, right here, and the second date is October 14th, here.
Dr. Budd, during the course of your investigation, were you able to come to a conclusion about how Kitty Gibbs contracted the measles?
Yes, it was. Based on the knowledge that Kitty was at Wobbly Elm Daycare when she was at Wobbly Elm Daycare, and based on the knowledge that Wobbly Elm Daycare allowed David Rose to attend while he had a fever, my investigation concluded that Kitty was exposed to the measles by David Rose.
Thank you, Dr. Budd. You can stop sharing your screen now. And let's switch gears and talk about something called the personal belief exemption. Are you familiar with what that is?
Yes, I am.
And what is your understanding of the personal belief exemption?
The personal belief exemption is something under South Texas law. I believe it's Article 8506. It allows for parents or legal guardians to elect not to vaccinate their children when doing so is contrary to their personal beliefs.
Are you aware of whether anyone involved in this case attempted to invoke the personal belief exemption?
Yes, the Roses attempted to. The Rose family claimed to invoke this personal belief exemption for their son, David Rose.
Dr. Budd, how does someone actually invoke the personal belief exemption?
Well, according to South Texas law, a family is required to file a notice of their intention, and they have to file an affidavit with the state before that exemption actually kicks in and shields them from the vaccination requirement.
Based on the information that you reviewed, had the Rose family actually taken any of those steps to formally invoke the personal belief exemption?
No, they did not. They didn't take any of the steps necessary to actually invoke the exemption. So David was never actually shielded from vaccination requirements as required under South Texas law.
Thank you, Dr. Budd. We pass the witness, Your Honor.
Cross-examination,
Yes, Your Honor.
you may proceed.
Good afternoon, Dr. Budd. Can you see and hear me all right?
Yes, I can.
I want to start by talking to you about the role of the health department. The exact name of that department is the South Texas Department of Health and Public Safety, right?
Yes, that's right.
The health department, that's a government agency.
It is.
The health department is supposed to be an expert on matters of public health, isn't it?
Yes, that's right.
The health department, it employs medical doctors.
We do.
It employs immunologists.
Yep.
I'm sorry, sir, is that a yes to my question?
Yes, it is.
Thank you, doctor. It employs people with PhDs in public health, such as yourself.
It does.
The health department, it's supposed to protect the people of South Texas, isn't it?
That's right.
It's supposed to help people who aren't experts in medicine themselves.
That's right.
That includes protecting them from infectious diseases.
Yes, like the measles.
Let's talk about whether the health department did its job in this case. You're aware that in 2019, Wobbly Elm Daycare reached out to the state health department for advice.
Right. They reached out to one of our local offices in Allister City.
Well, sir, you're also aware that in 2019, Wobbly Elm Daycare reached out to the state health department multiple times.
I believe they reached out through their local department, but yes.
Sir, you're aware Wobbly Elm Daycare actually called the state health department multiple times, right?
Sure, I believe so.
They reached out for advice about measles vaccinations.
Yes.
They reached out for advice about that personal belief exemption you just mentioned on direct examination.
That's right, but we don't offer legal advice. We're not a legal department.
So that's a yes to my question. You know they reached out to your department for advice on the personal belief exemption.
They contacted us about the law.
Pat Brewer is the director of Wobbly Elm Daycare, right?
She is.
You never investigated who Miss Brewer spoke to?
No, I did not. My department investigates how the measles spreads.
So you didn't investigate when Miss Brewer spoke to somebody at your health department?
No, I did not.
Or what they told Miss Brewer?
No, again, my department investigates how viruses spreads.
You never investigated whether or not your department was able to give Miss Brewer any information about measles vaccinations.
No, well, again, my department isn't one to give legal advice. My department is one that investigates outbreaks after they occur.
So that wasn't my question. I asked, you never were able to determine if your department gave Miss Brewer advice on measles vaccinations.
No.
Now, sir, like you just mentioned, you know the name Ronnie Lee.
I do.
Ronnie Lee, he works for the health department.
He does.
You're aware that Ronnie Lee offered to help Miss Brewer advise about the measles vaccine, right?
Right. Ronnie Lee was supposed to lead the investigation, and I thought that was pretty unethical because Ronnie was supposed to lead the investigation into one of his friends.
Well, sir, I'm not talking about the investigation. I'm talking about before the investigation. You're aware that Ronnie Lee agreed to help Miss Brewer and advise her on measles vaccinations. You're aware of that, aren't you?
Well, I don't know exactly what somebody else might have agreed to, but if you say so, sure, yes.
You're aware Ronnie Lee never got back to Miss Brewer with answers before this outbreak occurred.
I'm not aware what Ronnie Lee did.
Let's talk about what the health department did once David Rose did get the measles. You found out about the measles outbreak at Wobbly Elm Daycare by watching the news, right?
Yes,
You then called the local branch of your health department.
that's right.
That local health department, they didn't call you.
No, I mean, again, as I said, it was delegated to the wrong person. I thought it was unethical to somebody to investigate their friend. So I decided it was appropriate for me to step in.
So bringing you back to my question, the local health department, they didn't call you.
Right. They didn't say that they were being unethical.
They didn't text you.
No,
You had to reach out to them.
that's right.
As far as you can tell, sir, the local branch of the health department did nothing to help Wobbly Elm Daycare before this measles outbreak occurred.
I guess not. No.
Now, sir, you mentioned earlier you don't give advice on the law, but sir, you just mentioned a law to us on direct examination, right?
That's right. That's my personal understanding.
You mentioned the personal belief exemption. You mentioned that was a statute on the books.
I believe so. Yes.
You told us you're aware with it. You're aware of it.
Yes.
Your Honor, may I have permission to publish constructively to this witness a copy of this law that he referenced on direct examination, a text copy?
Ms. Carib, what do you say about that?
No objections to that, Your Honor.
Okay, go ahead.
Ms. Owen, can we zoom in on the personal belief exemption law? Thank you, ma'am. Now, doctor, this is section 13203 of the South Texas Code, right?
Yes, it is.
This is that personal belief exemption law that you just mentioned.
It is.
And like you told us on direct examination, this law says that an affidavit needs to be on file with the governing authority, doesn't it?
That's right.
Your Honor, defense moves Exhibit D into evidence, just this portion of it.
I'm sorry, what portion of it?
The portion that's displayed on the screen right now.
Okay. Response?
There's no objection to that, Your Honor.
All right, if there's no objection, then I'll admit it.
Thank you, Ms. Owen. So let's talk about your criticism of Wobbly Elm Daycare. You know Wobbly Elm, you investigated them, right?
Yes,
You know the people who work there.
I do.
They're custodians,
Yes.
teachers,
Yes.
administrators.
Yes.
They're not medical doctors.
I don't suppose not. No.
They aren't immunologists.
No.
They aren't PhDs like yourself.
No, they're not.
Sir, like you discussed, in 2019, one of the families at their daycare invoked the personal belief exemption.
A family tried to, but yes.
That was the Rose family.
Right. They were the ones that attempted to invoke the exemption.
In South Texas, parents do have the right to not vaccinate their children.
They do.
Here in court today, you claim that Wobbly Elm had the right to kick David Rose out of the daycare.
Right. Because somebody didn't actually claim the exemption as mandated under South Texas law, they weren't shielded from it.
So that's a yes to my question. You think the daycare should have kicked David Rose out?
Well, I think they could have, yes.
But the health department, they publish guidelines.
We do.
Those guidelines, they don't advise the public about the personal belief exemption.
No, again, we're not a legal department. We primarily investigate outbreaks. So no, we don't advise on the law.
Here in court today, you say the daycare, they should have told other parents that David Rose should have been vaccinated.
I do.
But there are privacy laws here in South Texas, aren't there?
They are. They shield that personal specific information, but it is my understanding that you can still disclose generally information, and you can also disclose if there's a public health threat.
Sir, we'll get there. There's a law called HIPAA, isn't there?
There is.
And that law, it regulates what private medical information people can disclose.
It does.
Thank you, Dr. Budd. Your Honor, we have no further questions for this witness.
Understood. Is there a redirect of the witness?
No redirect, Your Honor. We just ask that Dr. Budd be able to step down, even though he will remain with us throughout the course of today's proceedings.
Sounds good to me.
And with that, Your Honor, the plaintiff rests their case in chief.
All right. Does the defense have any motions?
Yes, Your Honor, the defense has a motion we'd like to bring outside the presence of the jury.
Yeah, that's where I was going next. So we're going to excuse the jury now. Ladies and gentlemen, we're going to take a break. Probably we'll be back with you at 3 p.m. Central Standard Time. But go ahead, Mr. Moss. Are you going to bring the motion?
Yes, Your Honor, I will.
What is your motion?
The defense moves for under Rule 50 for judgment as a matter of law. No reasonable jury can conclude that the plaintiff has met its burden. The plaintiff has failed to prove that a daycare has any duty, let alone permission, to disclose a child's confidential medical information to third parties. And without that element, Your Honor, the plaintiff's claim for negligence fails as a matter of law.
Does that conclude your motion?
Yes, it does, Your Honor.
All right, Mr. Hoffman, are you going to respond?
Yes, Your Honor. If I could direct my co-counsel to share her screen, I'm going to point you to a portion of South Texas Civil Code. The legislature in South Texas has decided to codify the common sense duty that if you're aware that someone has been exposed to grave harm, you should intervene, and you are precluded from civil liability for doing so should you incur civil liability. This would be a moment where a child was clearly in danger because there was someone unvaccinated. Pat Brewer knew that David Rose was exposed to his uncle. And further, a duty should abide in this negligence case because the scope of duty is foreseeability. And we saw testimony that this director of this daycare was aware not only that the child who attended the daycare was attending unvaccinated, but that her sister at home was unvaccinated. Further, it's foreseeable that if you get something at the daycare, you will spread it to your siblings as a matter of common sense. And sorry, Your Honor, and just taking all inferences in the light of the non-moving party, we would think that a reasonable mind could find that burden has been met here.
I just wanted to make sure I understand the motion. The motion, as I understand it, is one of all the elements of tort or negligence. What the defense is saying is there is no duty. Is that the sum and substance of the motion?
Yes, Your Honor.
All right, deny the motion. All right, let's take a break. We'll be back at 3 p.m. We'll resume with the defense case. If you will mute your mics and stop, we'll rejoin at 3 o'clock. Thanks, everybody. Welcome back, everyone. It's 3 o'clock. You're right on time. I'm trusting that the jury is back. But before we bring them in and seat them, I want to confirm where everyone is on their time. My understanding is the plaintiff has 38 minutes, 12 seconds plus 2 minutes of rebuttal left, and the defense has 41 minutes and 41 seconds. Is that consistent with your understanding?
Yes, it is, Your Honor.
All right,
Yes, Your
very
Honor.
good. Okay, so I will now call the jury back into the box. They are seated. Defense, you may proceed.
Yes, Your Honor. Defense calls Pat Brewer to the stand.
All right, is this Mr. or Miss Brewer? I apologize. Miss Brewer, good to see you. I remind you that you are under oath.
Good afternoon, ma'am. Would you mind introducing yourself to the members of the jury?
Yes, my name is Pat Brewer.
What do you do for a living, Miss Brewer?
I run Wombly Elm Daycare.
What's the Wobbly Elm Daycare?
It is a daycare for young children. Our youngest are just a couple months old, and then we go up to about 5 because that's when they start kindergarten.
How many children attend Wobbly Elm?
We have about 65.
And for how long have you run the Wobbly Elm Daycare?
I have been running it for about 10 years now.
I want to talk to you now about how Wobbly Elm handles health issues. As part of running a daycare, have you ever had to confront any health issues?
Yes, of course.
Would you mind giving us some examples?
Yes, so we have a vaccination policy in place, but at the same time, we also have to think about a family's privacy rights, and we have to think about whether other families can know if that family has a child that isn't vaccinated, and it's children's health and it's supposed to say private, so it gets really tricky.
Do you yourself have any specialized experience in public health?
No.
So how do you know what to do when these health issues come up?
We reach out to the state health department.
Which health department are you referring to specifically?
Oh, actually, we rely on both the state and local health departments.
When you say you rely on the health department, what do you mean?
So if we have a tough question, we call them directly. And we ask them, you know, what we can do, what's safe to do, what's legal to do.
Why is it that you rely on the health department?
Because I don't usually know what to do, and they're the experts, so they do.
Let's talk about now what happened in this case. In your electronic notebook in front of you, can you turn to Exhibit S and let me know when you're there?
Yes, I have it.
What is Exhibit S?
This is the vaccination policy for the daycare.
Your Honor, let the record reflect I'm displaying for the members of the jury what's been previously entered as Exhibit S.
Very good. You can proceed.
Ms. Brewer, was this vaccination policy in effect in 2019?
Yes, it was.
Now, when it says here, immunizations are required of all children attending Wobbly Elm, how do you decide which immunizations are required?
We follow the public health guidelines, like it says in the last sentence.
Now, toward the bottom of this document, it says, while sometimes there are medical reasons for not giving your child a particular immunization, we are not permitted to make exceptions. Have you ever had a family ask you for an exception?
Yes, we have.
Who?
It was the Roses. It was the first time I had ever had a family ask me to make an exception.
Let's talk now about the Roses. How do you know them?
Their son David goes to Wombly Elm, and I am also in a relationship with David's uncle, Ted Mullins.
How do you know that the Rose family, they wanted an exception to your vaccination policy?
They sent me an email.
Do you recognize Exhibit Q in the electronic notebook you have there?
Yes, I do. This is my email exchange with the Roses.
When did this email exchange take place?
I emailed them on April 15th and they replied on April 17th of 2019.
Your Honor, let the record reflect defense is displaying what's been previously entered, Exhibit Q, to the members of the jury.
Understood. You can proceed.
Let's start with your email to the Rose family. Why did you send this email?
So David had just celebrated his first birthday, and so we needed his MMR vaccination records.
What does MMR stand for?
It stands for measles, mumps, and rubella.
Well, let's scroll up to Mrs. Rose's response to you. When Mrs. Rose here said, no, we will not be doing that, what did you do?
I then reached out to the state health department
Why did you reach out to the state health department?
because this is a complicated issue.
Why did this issue seem complicated to you?
Because on one hand, we had a vaccination policy, but on the other hand, I know people have religious rights and they have the rights to raise their children the way that they want to raise them. And we didn't know what to do. We didn't know if we could tell other parents about this. So we didn't want to violate any rules. And so I wasn't sure what I could do.
So let's talk about what happened when you did reach out to the state health department. When was that?
It was in the summer of 2019, after the Roses refused to get David vaccinated, but it was before the outbreak.
What information were you seeking from the health department?
I wanted to know what to do about the Roses and the whole situation. Did I let David attend school without the vaccine? Did I have a choice? Did I tell the other parents? I needed guidance. I didn't know what to do.
How did you contact the health department?
I called the state health department on the phone, and I also met with a local health official.
How many times did you call the state health department?
Oh, it was many times. I don't remember the exact number, but I called them quite a few times.
What did they tell you?
They told me that they would get back to me.
Did the state health department ever get back to you and answer your questions?
Unfortunately, no, they did not.
Did the state health department ever tell you to look somewhere else for the information?
No, they did not.
You mentioned you also met with a local health department official. Who was that?
Yes, with Ronnie Lee.
Did Ronnie Lee answer your questions?
No, he also did not get back to me.
So what did you do when neither state nor local health department officials would answer your questions?
I waited. I didn't know what else to do. I didn't think I could kick David out of daycare, and I didn't think I could disclose his medical information to other parents. So I just waited.
Let's talk about the outbreak. When was it that you realized there was a problem?
On October 21st of 2019, I learned that David Rose had the measles.
What did you do?
I shut down the daycare. I notified parents. I brought in cleaning crews. I did everything that I could think of.
After the outbreak happened, did you have any further communication with the health department?
Yes, they showed up then. They came to investigate us.
Did the health department ever explain to you why they didn't get back to you before there was an outbreak?
No, they never did.
Thank you, Ms. Brewer. You passed the witness, Your Honor.
Cross-examination,
Yes, Your Honor.
proceed.
Ms. Brewer, let's start by talking a little bit more about your vaccination policy. Your Honor, I'm sharing my screen with Exhibit S.
Go ahead.
Ms. Brewer, are you seeing Exhibit S, your vaccination policy?
Yes, I am.
This is the policy that you gave to parents whose children attended your daycare.
That is correct. Yes.
You gave this policy to the Gibbs family.
Yes.
In this policy, You promise that you will require immunizations for all children attending Wobbly Elm Daycare when appropriate.
It says that immunizations are required, yes.
In this policy, you recognize that there are some times where children can't or don't get vaccinated, right?
That is correct, yes.
But in this policy, you promise parents that despite that, your daycare wouldn't be making exceptions.
Correct.
But then you did.
I did not make an exception to my policy.
Well, you didn't enforce this policy for David Rose.
I was waiting for feedback. I didn't know what I could legally or safely do.
So that's a no. You didn't enforce this policy with David Rose.
I enforced it to the best of my ability with David Rose for what I thought I was legally allowed to do.
Now, you talked to us a little bit ago about how you found out in April that David Rose would not be getting the measles vaccine.
That is correct, yes.
At the time, David Rose was 15 months old.
Yes,
And this was the first time you say that you had found out that David Rose would never be vaccinated.
I reached out regarding the MMR vaccine and his parents informed me that he would not be getting it.
And this was the first time you learned that he wasn't receiving any vaccinations at all, right?
This is the first time that I had been told about the MMR vaccine. Yes,
But David Rose had been attending Wobbly Elm Daycare since at least January of 2019, right?
yes, that is correct.
And you were here when Dr. Budd was speaking to the members of the jury?
Yes, that is correct.
You heard Dr. Budd tell us that by the time a child is 12 months old, they actually need 6 vaccinations, not just the measles.
That is right.
By the time you reached out to the Rose family about the measles vaccine, David Rose was late on 5 other vaccinations already.
My vaccination records and everything had been complied with up into this point, which is why at this point I reached out for help. Up until now, we had not had any problems.
You hadn't had any problems with your vaccination policy, even though David Rose had not received any of those other 5 vaccinations?
Up until this point, the vaccination policy had been complied with. This was the first problem that I had, and that is why I did not know how to handle it.
Well, let's break that down a little bit, Ms. Brewer. If you're enforcing your policy, your vaccination policy, that means that children that can be vaccinated are getting vaccinated, right?
I'm sorry, can you repeat that?
If your policy is being complied with as written, like you just told us it was, that means that children that can get vaccinated are getting vaccinated.
That is correct, yes.
David Rose needed 5 vaccinations and didn't have any of them.
Up until this point, the vaccination policy had been complied with.
Well, you were here when Moira Rose's deposition was read into the record, right?
That is correct, yes.
You heard that deposition testimony which said that David Rose had not complied with your vaccination policy.
This was the first time my vaccination policy wasn't complied with. If it hadn't been complied with sooner, I would have reached out to the health department sooner and I would have hopefully been able to avoid this situation, but it had been complied with.
You are good friends with the Rose family, right?
Yes, I am.
You're dating David Rose's uncle.
That is correct, yes.
Now, when Moira Rose claimed this personal belief exemption, you, of course, did your own research too.
To the best of my ability. I'm not a doctor, I'm not a lawyer, but yes.
Of course. So that's why you told us you called the health department multiple times?
I did. I called the state health department multiple times, yes.
And when did you contact an attorney to ask about this law?
I was waiting for the state health department to get back to me, so I did not contact an attorney.
So you didn't reach out to any legal professional to ask about a South Texas law?
No, I did not. I was waiting for the state health department to get back to me about vaccines, which seems like, an area that they should be able to help me with.
But you, of course, said you researched the law to the best of your ability.
Yes.
So you knew that South Texas law requires that parents invoking the personal belief exemption actually tell the state of South Texas that they're going to do it, right?
I did not know.
So you researched the law, but you didn't know that the law said that parents have to tell the state?
Like I said, I'm just a daycare director. I'm not a lawyer. I'm not a doctor. I did not know this.
Let me ask you this then, Ms. Brewer. In the time between April of 2019 and October of 2019, did you ever read the personal belief exemption statute at all?
I did not know.
You didn't look it up once?
I didn't know. I didn't even really realize there was a statute. I kind of just looked into like the privacy stuff. And it was really confusing, and I stopped.
So
I
then,
was waiting.
I'm sorry, Ms. Brewer, you can finish.
I was waiting for the experts to get back to me about it.
So then let's talk about those privacy laws that you just mentioned. Those are HIPAA and FERPA.
I believe those are the names, yes.
Now you understand that privacy laws protect an individual person's privacy.
Yes, which is why I didn't know what to do. I didn't think that I could disclose it because it's medical, it's private.
But you never told parents whose children attended your daycare, just generally, that you were changing your vaccination policy.
No, I did not.
You never told parents, without naming David Rose specifically, that you were making an exception to your vaccination policy.
I did not know.
You never told parents that your policy was now going to recognize something called the personal belief exemption.
I wasn't even really sure how all that would work, so no, I did not.
From April to October, you didn't tell parents anything about all this.
That is correct, because I had no idea what I could or could not tell them at this point.
So is that a no?
No, I did not.
Then let's put policies aside for a minute. Right before the measles outbreak at your daycare, David Rose had a fever. You know that, right?
He was brought in and we were told he had a bit of a fever and to watch it. So I guess yes.
So to be clear, you knew David Rose had a fever.
Yes, I guess.
You let David Rose attend daycare with a fever.
I guess so, yes.
You didn't tell David Rose's parents that they had to keep him at home until he wasn't sick anymore?
No, I did not.
You didn't say that to the Rose family, your friends?
No, I did not.
Thank you, Your Honor. We pass the witness.
All right, redirect.
Yes, Your Honor. Ms.
Proceed.
Brewer, are you a medical professional?
No, I am not.
Objection, Your Honor, to asked and answered.
It's fine. You brought it up in cross. He gets to ask it.
Ms. Brewer, are you a medical professional?
No, I am not a medical professional.
Thank you, Ms. Brewer. Your Honor, we ask that the witness be allowed to step down.
All right. She's going to stay with us, but she's leaving the stand. Fair enough. Who is your next witness?
Your Honor, we call Ronnie Lee to the stand.
All right. Is this Miss Lee or Mr. Lee? All right. I see Mr. Lee. Welcome, Mr. Lee. You have been sworn. You may proceed.
Good afternoon.
Good afternoon.
Would you please introduce yourself to the jury?
Hiya, my name is Ronald Lee, but people call me Ronnie.
Mr. Lee, what do you do for a living?
I work for the Capital County Health Department.
What's your position?
I'm an assistant inspector.
And what do you do as an assistant inspector for the health department?
Well, I'm supposed to make sure that all the different businesses are doing what's in the Capital County Health Department health code.
I want to focus on your qualifications for the job of assistant health inspector. Do you have any degrees?
Well, yeah, I've got a high school degree. Do you call that a degree? I went to high school.
What about college or postgraduate degrees?
No, I did the uni thing for like one semester, I think, but it wasn't for me, so I dropped out after one term.
Okay. Before the health department hired you, what kind of education did you have? in public health?
Oh, in public health specifically? Yeah, none.
Before the health department hired you, what kind of experience did you have in public health?
Well, before this job, I worked as a gardener, or my boss said to call it a landscaper. So I was a landscaper, but yeah, I don't. That probably doesn't count, does it? So yeah, probably none.
After the health department hired you, what kind of education did they give you in the field of public health?
Oh yeah, so when I started, they gave me 3 days of training.
Have they given you any other training since?
Well, they give me like manuals and books and things to read, but no, I haven't done any. Like, I haven't done training like I did at the beginning again.
Let's talk about your involvement in this case. Are you familiar with the local measles outbreak that occurred in 2019?
Yeah, I am.
How are you familiar with the local measles outbreak?
So I'm the health department inspector who consulted with Wobbly Elm Daycare back then in 2019.
Who at Wobbly Elm did you communicate with?
With Pat Brewer.
And who is Pat Brewer?
I think she's the director of the daycare, but we go back for years. I've known her for ages.
When you say you consulted with Wobbly Elm about the measles outbreak, what do you mean by that?
Well, they came to me and they had a couple of questions. They wanted to know something about it's a personal belief. I can't remember if it's exception or exemption, but it's one of them two. And then there was a question about what they're allowed to tell other parents about that.
When Wobbly Elm came to you for advice on these two issues, what did you do?
Well, I tried to look into them and, basically give Pat advice and tell her what the health rules were.
Let's take those two issues one at a time, starting with the personal belief exemption. When did you consult on that issue?
I would have been early 2019, like probably springtime.
What question were you trying to answer?
So basically, I was trying to see if a parent is allowed to not get their children's vaccinations if they don't believe in it or don't want it, that sort of thing.
How did you go about trying to answer this question?
So I looked at some rules.
Sir, after you looked at some rules, what, if anything, did you tell Wobbly Elm?
Yeah, well, I basically told Pat that based on what I found, people are allowed to just do what they want, kind of. Like, it's kind of up to the parents if their kid gets vaccinated or not.
When you gave this advice to Wobbly Elm, what was your title with the health department?
Oh, I was an assistant inspector, same as now. Yeah, I haven't gotten promoted or anything.
Now let's talk about the other issue you consulted on, whether other parents should be informed. When did you consult on this issue?
That would have been after the first issue, so probably like May 2019, I think.
What question were you trying to answer here?
So here, I was trying to see if you've got that one parent who doesn't want to get their kids vaccinations, then can you or should you tell the other parents about that one parent not getting the vaccinations?
How did you go about trying to answer this question?
So I looked at some more rules, some privacy rules.
Which privacy rules?
They've got funny names. I can't remember what they're called.
Have you ever heard of HIPAA?
No, I think that was one of them. That does ring a bell.
To your knowledge, what is HIPAA?
I mean, it's a privacy rule, but I couldn't really tell you beyond that.
Sir, when Wobbly Elm reached out to you about this issue in 2019, what did you tell him?
Basically I told them, don't worry, I'll get back to you with an answer.
When did you get back to them with an answer?
I didn't.
What do you mean by that?
Well, it was really tricky and I couldn't figure it out. I never found the answer, so I just kind of forgot to get back to them.
I want to put this all together. During those instances when Wobbly Elm reached out to you as assistant health inspector about these health issues, what resources did you provide them?
What do you mean by resources?
Sir, what resources does the health department have regarding vaccinations?
Well, up in the office, we've got these like charts that I think like show like when kids are supposed to get different shots.
Without going into the content of those charts, do they include the schedule for measles vaccinations?
I think so. I think they've got all of them up there.
When Wobbly Elm reached out to you regarding these vaccination questions, which of those charts that you just mentioned did you provide them?
Did I give to Pat? Oh, no, none of them. I never gave Pat anything.
Thank you, Mr. Lee. Your Honor, pass the witness.
Cross-examination.
Your Honor, may I proceed?
You may.
Good afternoon, Mr. Lee. Can you see me?
Yeah, I can see you fine.
As you mentioned on direct, you're an assistant county health inspector.
Yeah, that's right, Capital County.
Your normal responsibilities are checking out restaurants for health code violations.
Well, we do all sorts. That's one of the things I do. Yeah, I do that quite a bit.
And you offered to give Pat Brewer advice, right?
Yeah. It sounded like she had a real problem. So yeah, I offered to give her advice.
About HIPAA.
Well, yeah, I mean, that ended up playing into it, yeah.
About FERPA.
Yeah, I think is that another privacy rule?
Yes, it is. And what about the personal belief exemption? Did you offer to look into that for Pat?
Yeah, so that's what she'd come to me about. She talked about there was this kid who their parents had wanted a personal belief exemption. So I was trying to look into that for her.
So you offered to research all these things for Pat, to study up on them.
Yeah, I was trying to help.
And you made that offer over drinks, correct?
I did, yeah.
And when you say that Wobbly Elm reached out to you, what you're actually saying is that Pat Brewer brought this up over your weekly drinks.
Yeah. Pat asked me for help because she knew I worked with the health department and she thought I might be able to help.
You and Pat are good friends?
Yeah. We graduated high school together.
Right. You've been friends since high school?
Yeah.
And you stayed close throughout?
Yeah. We still live in the same town and all, yeah.
And as I mentioned, you get drinks weekly?
Just about.
You tell Pat what you're doing for the health department?
Right. Yeah, I try to help her out and I tell her what's going on at the health department.
If there's mice in the kitchen at Tropical Cafe, you tell Pat?
I mean, I might not get into all the details. Depends if something's interesting or not, really.
And if there's something wrong at the daycare, Pat tells you?
Yeah, she tells me about some of the things that are going on at the daycare. Like, we just catch up, you know?
So you know a lot about each other?
Yeah, we're mates.
And when Pat came to you over your weekly drinks, the two of you discussed David Rose?
Yeah, that was the kid who needed or didn't have his vaccinations.
And Pat Brewer told you David was unvaccinated in that conversation?
Yeah.
Breaching David Rose's privacy to you?
I don't know what the privacy rules were about that. That's exactly what I was trying to look into, is what she was allowed to say.
So what advice did you offer Pat over drinks? What exactly did you say when Pat said that she was worried about breaching privacy?
Yeah, so there were a couple of things. So there's multiple conversations because, like you said, we met like every week, basically. So at first she told me that there was someone who'd said something about this personal belief exception, and like she wanted to know what that was and what she could do about it, and like whether she had to go along with it. So I tried to look into that for her and find out, and that's when I found out that there
Just
is.
I know about. Sorry, Mr. Lee, I'm sorry to cut you off, but I really just want to know about
Objection, Your Honor. Under Rule 611, I ask that my witness be allowed to finish his answer before opposing counsel asks this question.
Well, Mr. Lee, are you finished with your answer, or do you have something else of substance to add?
Well, I wasn't sure what he was asking because we had a couple of conversations.
All right, Mr. Hoffman, why don't you back up, start over, break it down for the witness?
Yes, Your Honor. Pat Brewer told you that David was unvaccinated.
Yes, that's right.
And not only did she tell you that David was unvaccinated, she told you that David was allowed to attend the daycare with a fever.
Oh, no, wait, when are you talking about? The vaccination, that was back in April that we were talking about that.
You knew that David Rose was allowed to attend Wobbly Elm Daycare with a fever.
Well, now you're talking about, this is ages later. Now you're talking about like October?
In October, David Rose was allowed to attend Wobbly Elm Daycare with a fever. You're aware?
Yeah, I think so. I think that came up that David had a fever.
And the daycare knew David had a fever at that time.
I think so, yeah. I mean, I wasn't there.
But from your knowledge, you knew David had just been exposed to his uncle?
What, like, I think, yeah, his uncle's Ted, right?
His uncle is Ted, who had just been to Samoa where there's an epidemic.
Yeah, I mean, I don't really follow what goes on in Samoa, but I think Pat said something about that.
And you didn't tell Pat that it was a bad idea to let a child with a fever attend Wobbly Elm Daycare.
I mean, kids get fevers all the time. It can mean anything.
So Pat trusted you over a few drinks.
Yeah, Pat trusted me, yeah.
And Pat knows fully who you are.
Yeah.
Nothing further. Pass the witness.
Okay, any redirect?
Brief redirect, Your Honor. Mr. Lee, Pat Brewer is aware that you've been working at the health department for 5 years now, right?
Yeah, so like I said, I've been meeting with Pat for drinks. So when I got the job originally, like we've been talking about it since then.
No further questions, Your Honor.
All right, are we done with this witness, or is there anything else we need to do?
Yes, may Mr. Lee be excused, Your Honor?
All right, he's not a party, so he can leave the courtroom if he chooses. Mr. Hoffman, or I'm sorry, Ms. Owen, what else does the defense have?
With that, the defense rests, Your Honor.
All right, have we reached the end of all evidence for this matter? What says the plaintiff?
Yes, Your Honor. Plaintiff is ready to proceed into closing statements.
All right, and defense, I understand you have presented all of your evidence, so you're done at this point. Okay, so there may be motions. We probably should let everyone stretch their legs. So members of the jury, we're going to excuse you. There may be a few matters that counsel and I need to take up. What we will do is at 3:45 p.m., we will return to the courtroom for closing arguments. So the jury's excused. Counsel, are there any motions that you want the court to consider before we put this to the jury?
No defense motions, Your Honor. Defense is ready to proceed.
All right, any plaintiff's motions?
No, Your Honor.
Okay, all right. So are there any concerns or are there anything that we need to think about before we do closing argument? Are there demonstratives that are going to be used? Any video clips, anything like that that I need to know about before you speak to the jury?
Nothing for the plaintiff, Your Honor.
What about defense?
Your Honor, defense does have demonstratives. They include Exhibit S, which has been entered into evidence, Exhibit Q, which has also been entered into evidence, and the jury verdict form.
All right, so you're just going to show those on your screen then? Okay,
Yes, Your Honor.
that's fine. All right, so I have no problem with anybody showing evidence that has been admitted or the jury form. So my understanding is the only thing that y'all are going to show the jury and talk about are two admitted pieces of evidence, two exhibits, and the jury form. Is that correct?
Yes, Your Honor.
Okay, all right, good enough. Sounds like we're squared away. 10 minutes on break. We'll see you back at 3:45. Please mute your mics and block your video.
Yes, Your Honor.
All right, welcome back, counsel. Before we put the jury in the box, is there anything that the court needs to consider before we go to closing argument?
No, Your Honor, before closings, the plaintiffs just request 2 minutes for rebuttal, but beyond that, nothing else.
No, I was going to give you a time check, and you can use all of this time under the rules. Whether or not you want to do that is up to you, but plaintiff, you've got 25 minutes and 41 seconds if you want to use it. I know you want 2 of that for rebuttal. And defense, you got 24 minutes, 33 seconds. So I believe both of you should have adequate time to argue your case to the jury. Are we squared away? Are we ready to proceed?
Ready to proceed, Your Honor.
All right, I'm going to call the jury back in the box. The jury is now seated. Plaintiff, do you wish to give a closing argument?
Yes, Your Honor.
You may proceed.
May it please the court, opposing counsel, members of the jury, the defendant's policy was a promise. And when you make a promise, you keep it. And if you break a promise, you tell someone. Wobbly Elm Daycare had a policy, and this policy made a promise to parents: we will protect your children. And when you make a promise like that, you don't make exceptions, because a promise with exceptions is empty. And that's exactly what this defendant daycare made to the Gibbs family, an empty promise. And you heard today what happened because of that empty promise. The Gibbs family put their trust in a daycare that didn't deserve it. They sent their daughter into the care of the defendant, believing they would try to protect her, but they didn't. Kids got sick when it would have been easy to keep them safe. Now, that's why the plaintiffs have brought a claim of negligence against the defendant daycare. Now, negligence means the failure to use ordinary care, which means that we had to prove to you today, first, that the defendant daycare owed the Gibbs family a duty, second, that they breached that duty, and third, that the Gibbs family was harmed because of that breach. To put it simply, we had to prove that this daycare made a promise, broke that promise, and that because they broke that promise, the Gibbs family suffered an injury. But we couldn't just tell you those things today. We had to prove them to you too. And we had to prove them by a preponderance of the evidence, which just means more likely than not. We had to prove to you that yes, it is more likely than not that it was the daycare that caused Kitty Gibbs and Tennessee Gibbs to get sick, that it was the daycare's employees that allowed the Gibbs children to contract the measles, and we've met this burden today. So first, we had to prove that the daycare owed the Gibbs family a duty, that they made them a promise, and today you heard about that promise, the vaccination policy at Wobbly Elm Daycare. This policy stated that vaccinations were required for all children before that child could attend. And as children got old enough for more vaccinations, this policy promised that this daycare would require those too. This policy promised parents that this defendant would not make exceptions. And you heard today why this is so important to the Gibbs family. Twyla Sands took the stand today and told you about her daughters, Tennessee and Kitty. You heard about Tennessee's tragic diagnosis, that at the age of 9 months old, she was diagnosed with liver cancer, and that this made Tennessee immunocompromised, meaning that she could contract diseases easier than you or I could. And this meant that Tennessee could not attend daycare. But even though Tennessee couldn't, her younger sister Kitty could, and her parents wanted her to have as much of a normal childhood as she could. So when it came to finding a daycare for their daughter Kitty, the health and safety protocols of that daycare were the most important thing for the Gibbs. You heard that when they walked into this defendant daycare, they explained their situation to Pat Brewer, and they asked her all the right questions. Do you require vaccines? What happens if kids show up sick? Will our daughters be safe? And you heard Pat Brewer's response when confronted with these concerns, when she was made aware of this family's struggle. The daycare made the Gibbs family a promise. They said, don't worry. They said, we understand. They handed them that vaccination policy. And when they did that, they made a promise. And the defendant daycare had a duty to make good on that promise. Next, we had to prove to you that the defendant daycare breached that duty. And what that means is that we had to prove to you that this daycare failed to use ordinary care, that they didn't act the way a reasonable daycare would have in the same or similar circumstances. Now, members of the jury, this is an easy one. Because this measles outbreak, it could have been prevented. It would have been as simple as this daycare following its own rules. But instead of that, they broke their own rules and they made empty promises to parents in the process. That's not reasonable. This daycare learned in April of 2019 that David Rose was not vaccinated. And they didn't just learn that David wasn't getting the measles vaccine. They learned that David had never been vaccinated and would never be vaccinated. And what you heard today is that by the time the daycare bothered to ask the Rose family for David's immunization records, the daycare had already failed to try and get immunization records for 5 other vaccinations that David Rose was already late for at the time. But despite all of this, they allowed him to attend anyway. Now let's be very clear. By allowing an unvaccinated child to attend the daycare, that's when the defendant broke their promise. That's when they breached their duty. The daycare had an explicit policy that no child would attend the daycare without the appropriate vaccinations, no exceptions, but then the defendant turned right around and made an exception anyway, over and over and over. And not only did they knowingly allow an unvaccinated child to attend the daycare, making an exception they said they would never make, they allowed him to attend for 6 months. April, May, June, July, August, September, October, not to mention all the months before that they had ignored their promise to get all those other immunization records. Time and time again, this defendant corporation knowingly, willfully broke their promise. Members of the jury, remember, the solution to this problem was a simple one. Stop letting David Rose attend. You heard today time and time again about what the personal belief exemption actually requires. It requires parents to tell the state you're invoking the right. It requires parents to file an affidavit. The Rose family did none of that. The personal belief exemption wasn't at play here. The daycare was fully within their right to enforce their policy, but they chose not to. So fine, the daycare chooses to change their policy. They choose to break their promise. At least tell parents what you're doing. Do something. But apparently at Wobbly Elm Daycare, rules are made to be broken. Because as soon as this daycare had a chance to make good on their promise, they turned a blind eye and looked the other way instead. This wasn't about protecting a family's rights. This was not about protecting privacy. This was about a corporation protecting their own bottom dollar, making sure that for better or for worse, these plaintiffs continued to pay to send their daughter into an environment that they were misled to believe was safe. But at the very least, despite all of these policies that were just for show and promises that were never kept, what you heard today is that just before this very measles outbreak at this very daycare, this defendant allowed David Rose to attend knowing he was already sick, knowing he had a fever. Now, the defense can tell you all they want that they had to let David Rose attend based on the laws that didn't apply to them, but there is nothing out there that says that a daycare is required to knowingly keep kids with fevers at daycare. There is nothing that requires daycares to keep kids with fevers that were just exposed to their uncle who was just in Samoa in the middle of a measles epidemic at daycare instead of sending him home until he's not sick anymore. Common sense alone will tell you that it's wrong, that it's unreasonable. Now, today, the defense has come before you and said that the defendant corporation trusted the experts. What experts? It's certainly not Ronnie Lee. The defense came before you today and has tried to convince you that the defendant corporation was reasonable for relying on Ronnie Lee, but then showed you themselves why that's so unreasonable. This was Pat Brewer's drinking buddy, who Pat Brewer knew since high school, who Pat Brewer knew had no requisite qualifications to deal with the issues that this daycare claimed to be so concerned with. It's not reasonable for this defendant to say they trusted the experts when that expert today at trial didn't even know the personal belief exemption, HIPAA or FERPA by name. And sure, maybe the state health department didn't answer the defendant's phone calls, but calling a government agency a couple of times over the course of 6 months and calling it a day, that's not reasonable either. This wasn't even a problem that this defendant daycare needed experts to fix. Pat Brewer could have done as little as Google the personal belief exemption, which she told you she did not do. And that would have given her all the information she needed to know that this exemption did not apply to the Rose family, that she could have told David Rose and the Rose family that David couldn't attend. But instead, they broke their policy, they broke their promises with no justification why. Next, we had to prove to you that the daycare's breach, their empty promise, caused the Gibbs family's harm. And to do that, we had to prove two things. First, that the daycare's breach directly caused the Gibbs family's harm. And that means that if the daycare had kept their promise, Kitty and Tennessee would not have gotten the measles. And second, we had to prove to you that a daycare's breach proximately caused the Gibbs family's harm. Now, that's just fancy lawyer talk for saying that the harm was foreseeable, that allowing an unvaccinated child that was exposed to the measles into the daycare around other children while already sick might foreseeably get other kids sick. And we proved both of those things today. You heard from Dr. Budd, this state's former public health director. He told you that Kitty Gibbs contracted the measles from David Rose, the unvaccinated child that the daycare knowingly allowed to attend. Without David Rose at the daycare unvaccinated, Kitty Gibbs would not have gotten the measles. Kitty Gibbs would not have given her sister Tennessee the measles. We wouldn't be here. If the defendant corporation had just kept their promise, the measles could have never come through the doors of Wobbly Elm Daycare, and we wouldn't have to be here today. David Rose took the measles to a daycare full of children who were too young to be vaccinated. And if this daycare had just done their job when they had the chance, the Rose family wouldn't have had the chance to put other kids in danger. And lastly, we had to prove harm. You heard a lot today about patient zero, vaccinations, privacy laws, incubation periods, and it's easy. It's easy to forget the real damage that occurred in October of 2019. Who's at the heart of all this? Twyla Sands took the stand today and told you about the harm her family suffered. You heard Twyla Sands talk about her daughter and how she woke up one Saturday with a fever and a cough, and then within 48 hours, both of her girls were in the hospital hooked up to machines. You heard about the 60 days and nights that the Gibbs family were in the hospital wondering if their daughters would be okay, and you heard why. Because Wobbly Elm Daycare broke their promise. Because that policy, it wasn't just a policy. It wasn't just a list of rules that were made to be broken. That policy was a promise that these parents believed, that they trusted. But because this defendant made exceptions, 2 little girls got hurt. So find the defendant liable. Thank you.
Defense?
Yes, Your Honor.
You
May
may
I proceed?
proceed.
The plaintiff just told you it's important for children to be vaccinated. Their whole case comes down to this idea that it's safer for children to be vaccinated. How do they know this, members of the jury? They know this because the doctors, they figured it out. In other words, when it comes to medicine, the plaintiffs want you to trust the experts. That's exactly what this daycare did. They called the state health department again and again. When that didn't work, they turned to the local health department. Once again, I'll get back to you. Fact of the matter is, members of the jury, the state wasn't negligent. They did exactly what we want ordinary people to do when they're confronted with a difficult medical question. They trusted the experts. Now today, we as the defense, we didn't carry a burden of proof. The plaintiff did. It was their job to prove to you that each and every element of their claim was true by a preponderance of the evidence. That means more likely than not. They failed to do that today, members of the jury. And they failed to do that because of the three facts we showed today. The same three facts that Ms. Owen told you about in our opening statement. This state's vaccination laws require professional expertise to understand. That's why the daycare consulted the experts, and the daycare did not cause the plaintiff's injuries. Let's take those one at a time. First, it requires professional expertise to understand this state's vaccination laws. Now, plaintiff's counsel, she just got up here. She told you this was an easy one. Plaintiff just told you that this was an easy situation for Wobbly Elm Daycare. Just tell all the parents David Rose isn't vaccinated. Members of the jury, we know it's not that easy because we're talking about medical information. There are few types of information in this world we take more sensitive, more confidential, more private than our medical information. And there are a few types of information that the law guards more closely. Our employers, they can't ask us what medications we take. Our doctors, they can't just go around and tell people what our x-rays show. Even our husband or wife, they can't go to our doctor and get our medical information without our consent. So when the plaintiff just gets up here and says, well, Wobbly Elm should have sent an email blast to the other 65 parents. Not reasonable, members of the jury. The plaintiff called Dr. Budd today to try to prove to you that's what they should have done. But Dr. Budd, he didn't prove that. He didn't bring you any statute. He didn't bring you any guidelines, didn't bring you any regulations showing that that's what the daycare should have done. Well, let's step back for a moment. Let's assume Stephen Budd, Dr. Budd, let's assume he's correct. Well, Dr. Budd, you heard it. He has a PhD in public health. He has years of experience in public health running the statewide health department. Dr. Budd is an expert. That's exactly our point, members of the jury. The state's vaccination laws, they require you to be an expert to understand them. The daycare is run by administrators. They employ teachers. They employ janitors. There was no way for them to figure out this problem on their own. That brings me to fact number 2. The daycare trusted the expert. Now, you heard from Pat Brewer today that she called the state health department. Then she called them again. Then she called them again, each time asking the same question: what am I allowed to do? What am I supposed to do? How do I protect the health and safety of one family while protecting the privacy of another? Members of the jury, plaintiff's counsel just asked you what experts? The expert Pat Brewer was trying to reach, you heard from him today, Stevie Budd. He was happy to talk to you. but he wasn't happy to talk to Pat Brewer. And when Miss Brewer couldn't get his department on the phone, that's when she reached out to Ronnie Lee. That's when she reached out to the only health department official who she could get to sit down and try to help her talk through this problem. But today, members of the jury, what did we hear? Ronnie Lee didn't have the answers either. It's not the daycare's fault. The health department hired someone with no college degree, no medical degree, no public health experience. The fact of the matter is, the daycare tried to consult the experts, but all the experts they found either didn't get back to them or forgot to. Members of the jury, plaintiff's counsel, they've been mentioning vaccines a lot, that there were other vaccines. I want to make something very clear for the members of the jury. No one in this case got tetanus. No one in this case got diphtheria. Members of the jury, no one in this case got polio. That doesn't matter. The plaintiff's counsel is trying to pull the wool over your eyes. Because what we heard today is that Pat Brewer wasn't negligent. The health department was. The health department is the one who didn't do their duty. Members of the jury, plaintiff's counsel wants to talk about promises. Well, they made a promise to you today in their opening statement. They promised you that they would tell you that Twyla Sands told Pat Brewer that Tennessee was immunocompromised. Plaintiff's counsel, they just mentioned that a little while ago, that the daycare was made aware of the Gibbs family's struggles. Well, when my co-counsel, when she talked to Ms. Sands on the stand, Ms. Sands was forced to admit that she had never said that before. That she had never told anybody in her sworn deposition that she told Pat Brewer Tennessee was immunocompromised. No, instead, members of the jury, the first time anyone heard that was here today in front of you. This right here is the verdict form. The judge is going to instruct you that negligence is defined as the failure to use ordinary care in the same circumstances. Let's talk about the circumstances of this case. A daycare. A daycare. Not a lawyer, not a doctor's office, not a hospital, a daycare is asked to make a decision involving medical and legal expertise. Negligence would have been trying to solve that problem on its own. Negligence would have been guessing. Prudence was calling the expert. On that jury verdict form we just took a look at, you can go ahead and you can write no next to Wobbly Elm. They weren't negligent. But that's not all members of the jury. Fact number 3, the daycare did not cause the plaintiff's injuries. Now, members of the jury, our hearts go out to the plaintiffs. Their younger daughter, Kitty, she got sick. Their older daughter, Tennessee, she got really sick. But this afternoon, when you took your oaths as members of this jury panel, you agreed to set aside your sympathy for the plaintiff when deciding liability for the defendant. And what the judge is going to instruct you is that the plaintiff had to prove that the daycare was the one who caused the injuries to the plaintiff. It wasn't the daycare who decided David Rose wouldn't be vaccinated. That was the Rose family. It wasn't the daycare who decided that Kitty Gibbs would be around other children who were unvaccinated, even though her older sister was immunocompromised. That was the plaintiff's. It wasn't the daycare who decided not to respond to the calls for help from someone who was just trying to do the right thing. That was multiple officials from the health department. Now, members of the jury, I want to be very clear. We aren't telling you to blame the Rose family. We aren't telling you to blame the plaintiffs. But you can't blame the daycare for decisions that they didn't make, for information that they never got. If you haven't already written no next to the daycare on this verdict form sheet, you would do it now. Now, members of the jury, vaccination today, it's a controversial topic. But after I'm done speaking, after plaintiff's counsel is done speaking, after you go back to that jury deliberation room, you don't have to decide whether vaccines are good or bad. You don't have to decide whether a family gets to decide whether or not their child gets vaccinated. You don't have to decide whether a business gets to or has to exclude somebody who hasn't been vaccinated. All you have to decide is whether we expect daycares to make these decisions or whether they're better left for the experts. We ask you to find Wobbly Elm Daycare not liable, because all they did was trust the experts. Thank you.
Ms. Carab, you get the last word.
Yes, Your Honor. May it please the court. Now, the defense has come before you and pointed their finger in any and every direction that they could. But remember, it was the defendant daycare that was in control. They were the ones in the driver's seat here. It was the defendant daycare that had the ability to stop letting David Rose attend because there was no law, nothing preventing them from doing so. It was the defendant daycare that had the option to, without naming David Rose, tell parents, we're changing the policy. We are making exceptions. Those promises we made to you, they were empty. There's that saying, when you know better, you do better. And without needing to talk to experts, without ever having to get in touch with anyone, this defendant daycare should have known better. They did know better. But instead of doing anything, they did nothing but break their promises to parents instead. So find this daycare liable. Thank you.
All right, ladies and gentlemen of the jury, that concludes the presentation. Normally at this time, I would read the jury charge or the verdict form, as it is called here, to you and then send you on your way to deliberate. But since there's really no need to do that under these circumstances, we're going to thank you for your service. I'm going to turn this back to the bailiff, and she's going to instruct all of us what we do next.
Thank you, Your Honor. So at this time, I would like for all judges to go ahead and shut their camera off, and as well as their mic. And then once you have turned in and submitted all your ballots to those that you need to, go ahead and turn your camera back on so that way I can know that you have finished. And once all cameras are on, I will go ahead and confirm that all ballots have been submitted. Once all ballots have been submitted, I will go ahead and let the judges go ahead and give their critiques. Thank you.
All right, and just so everybody knows, in the chat, there is a link for Mr. Cooper that will take the judges to their ballot. And so I hope everybody sees that. I believe that is the pathway to get you to where you need to go next. So Everybody, please mute. Please block your video and mute your mics and proceed to vote. Thank you very much.
Good afternoon, everybody, and welcome back. Sorry for the delay there. They're in the process of accessing all of the ballots from the various judges, and we'll be tabulating them in a secret vault in Dubuque, Iowa now, so that we can get the results out to the advocates. Advocates, feel free to turn your cameras back on and join us back here if you would. Witnesses as well, you're welcome to turn your cameras on and be part of the proceedings. Before we start with some critiques from the various judges, I just want to, as the Dean and President of South Texas College of Law, welcome everybody again to the South Texas Challenge for 2021 and congratulate the advocates today for a job very, very well done. You were exceptional across the board. Just wonderful. Your coaches will be proud of you. The witnesses were great. And they clearly had a little fun with it too, which is always an important role or part of when you are being a witness in one of these events. So congratulations all around. What we're going to do right now is I want to confirm with all the judges that you have submitted your ballot. Please wave your hand up, some confirmation that indeed all of the ballots are in. Chris, you're in? Good. All right, excellent. I just want to make sure before we do begin on that. What we'll do is I will ask each of the judges, and as I mentioned at the beginning, each of the judges today, each of the scoring judges is a past champion of the South Texas Challenge. So what I'm going to do is ask them to provide a very brief critique. There are 10 of them. So if they do 7 or 8 minutes each, we'll be here until tomorrow afternoon about 2 o'clock. So in order that you all can go in, hang on a second, I'm getting a message not to critique yet. Okay, apparently there is an issue gathering the ballots through the system. So I don't want to have any critiques until we confirm everything is done. Judges, you are probably getting a message right now in your notes to email your vote and your rank in. Please do that right now so that we can then move to the critique part. I want to make sure that we're doing this and maintaining the integrity of the voting. So let's hold off on any critiques until we get those done.
Could someone confirm whether, for the other judges, whether you've received the email or not? I have not.
Have you received, is there a message in the chat to you?
There we go. Thanks.
And if you would turn your video off while you're doing this, turn your video back on, judges, when you are completed. That way I know that it is in. All right, I've just been given confirmation that all of the ballots have been received, so we can move forward. Apparently, the system that has worked flawlessly until the final round decided while we are broadcasting live on YouTube not to work. So wouldn't it be the way? I was talking to the various judges before the round began and asked them what were some of the skills that they learned in advocacy that benefit them in their careers. And one of them is the ability to adapt and be flexible to changing circumstances, such as when the ballot counting doesn't work smoothly and you have to adjust. So anyway, what we will do now is turn it over to the guest judges, the former champions. Please, again, be brief in giving a quick critique to the participants. And why don't we start with our reigning champions, the 2019 champions of the South Texas Challenge, Mr. Pernell Jackson.
Hey, thanks. Congrats to both teams. I think if my colleague there, James, who was with me, I think if we had competed against either of you, we definitely would have had our hands full back when we competed. So hats off to both of you. I'll be very, very brief. Like I said, both of you did a really good job, both teams. I thought really every part of the trial was well done. The openings were great themes with both teams. I thought the opening was great as far as telling the story, laying out where you're going to go with the trial, and then you actually went that way. A lot of times, I think with these competitions, it's easy to just throw a theme out there, throw some stuff out there, and then people just kind of go off and do something else. And then I thought what was really good, kind of on the flip side of that, was that the closings actually mirrored the themes, which again, sometimes you'll have an opening, they're doing something, the closure does something, and they don't really meet. The examinations were excellent. Cross-examinations were great, exactly what you want to do. The witness doesn't give you the answer you think you need, nail them down to it, force them to give you the answer. Directs exactly what you want to do. Let them tell the story and just fade into the background. So again, going to be very brief. Thought you both did an excellent, excellent job. Thank you for having me.
Very good. Thank you. James Sullivan, your partner.
Yeah, as Pernell had mentioned, you guys definitely would have kept us busy had we tried the case against you last year or this year, or last time or this year. You clearly have all mastered Zoom trial advocacy skills, something that I never could have fathomed doing or working out well, but you clearly all have a great presence here on the camera. You make good use of the different spaces you're in, and you are really keen on interacting with the witnesses throughout the trial, despite not being able to look someone really face-to-face in the eyes and talk to them face-to-face. All day, on conference calls and Zooms where people are talking over each other and have to apologize over who's going to be talking now or next. And you guys seamlessly were interacting with the witnesses, which I thought was really, really impressive. And with the judge, also very impressive. Only a few instances of a little confusion like that. One little tip, I think, for those of you who have advocacy ahead of you, trial advocacy ahead of you, is something we had talked about in the pre-meeting that I only caught a brief glimpse of, but was to listen. I think in each direct and cross, especially the crosses, there were instances where you were all very focused on the answers that you wanted to hear, that you didn't hear what was being said. And I think you missed, those little diamonds in the rough, those little gems that can really make or break a cross-examination in a lot of instances. So don't think about what's coming next. Think about the moment and focus on the witness and what they're saying, because it really is a conversation. You're not talking at the witness. You want to listen to what they have to say and make use of it as best you can. So that's great advice going forward, but all of you clearly got, great foundational and beyond that skills. So excellent job all around.
Thank you very much. The previous year's winners included Lauren Lutton.
Hey everybody, and I'll just echo what the judges have said so far. Congratulations, and both teams did an excellent job. I'm just going to hit three of the things I thought were the highlights for me. Ms. Owens, I thought that your opening was excellent in both structure and pacing, but especially the outline that you did that really just made it very easy and laid it out for the judges to be able to follow and kind of gave us a roadmap for the rest of the trial. I thought Mr. Hoffman on your cross-examination, they made a strategic decision to play that witness the way that they did for their direct. And I thought you dealt with it with just one question on your cross. And I don't know if that was planned or not, but I wrote it down. That last question you asked, Pat knows fully who you are. And I was just like, well, that just in one question took care of that. And I thought, Haley, your closing was really, Carib, is that how you say your name, was really good. And you used the things in closing that I had thought about through the trial. And I was like, oh, I hope they bring that up. And I hope they tie that up at the end. And I thought that was really good.
Very good. Thank you. And your partner was Daniel Lockerbie.
Hi, everybody. I'm Daniel. But yeah, no, again, I'm just going to echo everything that everyone else has already said. The things that sort of stood out to me were things that weren't things when I was doing this competition. So when you're transitioning over Zoom to an exhibit, just being like, I'm going to turn from this to the exhibit and I'm about to turn back from that to you. Like, it was just all very smooth and very professional. And everyone just seemed sort of very calm and reserved and unfathomable when it came to objections and responses. And I honestly got just a huge kick out of this entire thing. Everybody was on their A game. So yeah, thanks for letting me be a part of it. This was great. Really nothing negative to say about anybody's performance. It was great. A+ all the way through. Thanks.
Very good. Thank you very much. Going back now to 2014 and Maggie Randels.
Hi, y'all. I think I'm going to echo, everybody did a fantastic job, and congratulations on making this far and on sticking with it over Zoom, because I know Zoom trials and Zoom mock trial is not nearly as fun as in person and is much more difficult. Y'all heard a lot of positive things. I do have one sort of just critique thing to think about. And that's that sometimes less is more, especially on cross-examination. Sometimes you want to know, like, hey, I made my point and I'm going to sit down now. So it's just one little thought to leave you with, but overall, fantastic job to everybody.
Thank you very much. And now going back to the inaugural winners of the South Texas Challenge back in 2012, we'll start with Erica Aiken.
Great. I also think that everyone did an amazing job. I think that, at this stage in the competition, you all have some confidence that you guys are stellar advocates, and I cannot underscore that enough. In terms of specific feedback, I do have a couple of really minor critiques, and they're super, super minor because you guys are awesome. I do think that everyone, before I get to the critiques, everyone did a really good job of using hand gestures on Zoom, which I was like, this has to be, to take a lot of practice in order to get those down just right. I think that Ms. Owen in particular, you did a really good job of articulating the burden on your opening statement. I thought that Mr. Moss, you in particular, had a really good tone and did a really great job of really telling the narrative of a story on the direct examination of Ms. Brewer in particular, which I think was one of your key witnesses. Mr. Hoffman, I thought that you also had a really good pace, a really good tone. I thought that you probably had one of the best uses of hand gestures and movements. And I also thought that Ms. Carib, I thought that you also did a really good job on that direct examination of Dr. Budd. I thought that was a really stellar use of the facts in the case. I like that you also did a really good job of using the demonstrative, even though it was just a calendar. It was just so clean in the way that you were able to lay that out. You also had really good transitions, as everyone did. I thought that everyone had really, really great transitions, particularly Ms. Carib and Ms. Owen, when you say, well, let's break this down a little bit, or now let's talk about this. So I thought that that kind of helped, especially being on Zoom. A couple of things I think everybody can work on. One is that you can be passionate without being louder. And I think it's a little hard to get that on Zoom, because sometimes you may get a little louder in your tone or raise your voice, and it comes across as really loud compared to what you were saying when it's on the internet versus just like in a courtroom where you have to articulate more. So that's just something that I would watch. I saw a couple of points where, there were some things that were asked and answered already. I think you got to really watch that, because once the witness gives you the answer that you want, you don't want to give them room to change the answer. If you got a yes, but blah, 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 if yes is what you wanted, just move on, because now they can change their answer if you go back to it again. I thought that there were a couple of places where I thought everybody could slow down a little bit. There were some places, I think in particular, Haley, on your closing argument, which I thought was flawless. There were some places where your sentences were so long, it seemed as you got a little bit breathless towards the end of them, but they were great points and great articulations. But I would just encourage you to slow down a little bit there. But overall, I think that everyone did a phenomenal job, and you guys are really destined to do great things. And I'm excited to watch and see, how your careers shape up.
Thank you very much. Your partner was Michael Burns.
Hi, everyone. So I won't echo what all the judges before said, but I agree with them. Both pros and cons, but you guys all did a fantastic job. Just quickly, I'm going to hit highlights for each of you. Mr. Hoffman, I thought your approach on direct examination was fantastic. You let the witness testify. You did not take center stage, which is exactly what you should do on direct. You also had a great redirect. Ms. Carib, your cross was phenomenal, as others have mentioned. I had written down the points that I would cross on, and you hit them all. It was very strong. I didn't have any critiques for your cross. Ms. Owen, your opening was also fantastic. You projected confidence. One of the judges mentioned your pacing, which I agree with, was excellent. And the combination of the two made what you said all the more convincing. And it was a very strong opening statement. And Mr. Maz, your cross-examination of Dr. Budd was very good. You did a great job of locking down answers. The witness was particularly evasive, and you did a really good job knowing when to lock down an answer and when to let it go, which is what Erica said, is an important point to learn. And I think you did a really good job on that. So again, great job, everyone.
Very good. Thank you. Another partner of yours was Kevin Homiak.
So I will certainly echo all the positive things that have been said and leave you with the thought, before getting to sort of my substantive constructive criticism, that every single one of you today would be an incredible trial attorney. You're amazingly poised, confident, you're calm under pressure, you're obviously all extremely intelligent and have worked very, very hard. And those are all of the things that you need if and when you decide to go out into the world and be a trial attorney in any area of the law. And so know that every single one of you would do an incredible job if that's the career path that you ultimately decide on. So my comments are not to take away from that, is to try to make you even better than you already are. And my two global comments are, I think the openers could both have done a better job of making it clear what the jury's job was. So you have to imagine, as a juror coming into a courthouse, whether it's a state or federal courthouse, there is a million things going on. They have already been through, the first layer of jury selection, where they've been in this huge room, usually before they even get into the courtroom. They get in the courtroom, there's an hour of voir dire. They then sit down in front of you. They don't really know who everybody is. They don't really know what's going on. And your first job after introducing yourself is to make it abundantly clear what their task is, what their mission is. And I found myself listening to the openings thinking, well, what is the actual claim here? And I wrote down, and I may have missed it, but I don't think the word negligence actually came out in the openings. I don't think reasonable care came out. I don't think prudence or duty of care. Those are the sorts of things where the claim is negligence. You have to make that abundantly clear to the jury so that they know, okay, it's one claim. Here are the elements. Here's what I'm focusing on, because that gives them a framework to organize all of the evidence and all of the testimony that's coming in to fit those sort of blocks in. And you really almost want to sit down as the opener with your closer and say, okay, what are our claims? What are our elements? What's the outline? And how is our evidence and testimony going to fit into that and really focus on those key phrases so that the jury literally is sitting there. And if you're lucky enough, usually federal court judges will have the jury instructions decided and laid out and give them to the jury before you even give your opening statement. This isn't necessarily the case in every federal court, and it's often not the case in state court, but federal court judges usually will have the juries even with the verdict form and the special interrogatories. And so that's a great opportunity for you on opening, and it may be different in mock trial, to be able to say, look, take out that verdict form. That will give you the elements, and you can walk them through even on opening so that they know, okay, here's where I should be paying attention, here's what matters. And it becomes all the more important when you have more than one claim when you're actually out practicing into the world. So those are sort of my two things: be clear on the claims, be clear on the elements, but obviously everybody did a fantastic job. Congratulations on making it this far, and I wish all of you the best of luck.
Thank you very much. And your last partner was Chris Rollins.
Hi, everyone. Great job by both teams. Excuse me. I'll just echo some of the things, connect the themes. You both had very strong themes that you came back to a lot, and that was good. Take Kevin's advice, connect them to the elements, and hit those more. On direct, on cross, I agree with what Maggie said. You know, sometimes move on. Fine line between emphasizing a point that's a good point, and you did a good job getting it out, and being a little too hard on it. Move on. I will say I was generally very impressed with all of your poise and how you handled, especially on Zoom, but even outside of that, how you handled the procedure, the evidence, the rules, excuse me, and just if any of you got shaken at any point by a pretrial motion or by what the opposing side did, you didn't show it. And so I commend you all on that, on how you handled that. And finally, I'll say this would have been a fun trial. I'm challenging to do, and I hope you all had a great time. And that I hope that even in our COVID era, that doing this trial will have been as fulfilling for you as it was for me and my team. So good job, everybody.
Thank you very much. And I would like to turn it over very quickly to our presiding judge, Ken Johnson, for any comments he may like to make.
Well, thank you, Dean Barry. Great job, everybody. It's always good to see up and coming trial lawyers learning the skills and starting. I will tell you that I believe every minute that you've invested, every ounce of effort that you've put into this will pay dividends to you going forward. You're going to be so far ahead of other folks that are graduating that don't have a clue what to do. That's point one. Point two, you already know far better what to do than a lot of people that are out there practicing. But that doesn't mean that you should quit learning and growing. In fact, you need to do that every day. I've been doing this for 35 years. I've got more than 1,500 trial days. I've probably taken more than 4,000 depositions, and every day I'm trying to learn and do better. You should be doing that too. So in these competitions, I look for three basic things. The first is, do I understand the case after you've started talking? In other words, has the dispute been crystallized, and have I been told what I need to do as a juror? Both teams could have improved on that in my humble estimation. Number two, I'm looking for the good guy and the bad guy. Who wears the white hat, who wears the black hat based on the evidence. That's what I'm looking for from how the evidence is presented. And then most important is, have the advocates maximize the facts? Have they used everything in the record and built a story that clearly articulates their theme? When you do those three things and you do them with a plan and a purpose, you will be successful, I promise you. So let me just ask this question. What is the winning point? What is the winning point for the plaintiff? Both teams, what do y'all view as the winning point?
I think for us, it's that despite the policy, David still showed up with the fever right before.
Okay. Defense, if you were on the plaintiff's side, what's the winning point?
I would have to agree. I think the fever is a pretty compelling fact.
Okay, to me, the winning point is there was a rule, there was a policy, and the defendant never followed it. That's why the plaintiff wins. Okay, on the defense, what is the winning point for the defense? How do you rebut this bet the company case if you're on defense? Plaintiffs, what do you say?
I think it's that try as hard as they might. It was the health department that they were waiting on answers from.
Okay, defense, that's pretty much the case you tried. I presume that's your answer. I think that's a terrible position to be in on the defense. I think you're going to get your head handed to you. So here's my question. The baby, the young child, she went into the nursery and she was not vaccinated, right? Right? So what's the first line in the policy? All children are required to have a vaccination. The dumb defendant let kids in too young that weren't vaccinated, and then they made exceptions on top of that. They doubly lose. But on the defense, why wouldn't that be assumption of the risk? Isn't that a defense you could play? I don't know. But so that just goes to show everybody comes at these cases from different perspectives and different experience levels. And you've always got to be looking for what is the best approach to this case, this law, these facts. But going forward, I want to recommend 2 books for all of you. I'm going to show you one. You probably have seen it or heard of it. It's called Rules of the Road. Rules of the Road. It's written by Rick Friedman, a great trial lawyer. And what that helps you do is to understand how to organize your presentation, whether it's offense or defense. What the juries want to know is, why are we here? Are there any rules? Were those rules broken? What do you want me to do about it? Those are the 4 things every juror is going to want to know. You need to be able to answer those questions. The second book is called Case Framing. It was written by a lawyer up in the Northeast by the name of Mark Mandel, Mandell. It was written in 2015 or 2016. I would recommend, if you're going to do trial work, that you buy both of those books and you read them repeatedly. I'm reading actually Rules of the Road and Case Framing for about the 4th time, because I'm going through this process right now on a very large commercial case. And if you get a system, if you get a protocol about how you break a case down, it will get you to the finish line. And I hope that that's something else you can take from this event. Great job, guys. Keep working, keep learning. Congratulations for all that you've done to get here today.
Very good. So now I have the honor of presenting the awards. So I will share my screen in a second. Before I do, though, I have to acknowledge all of the hard work that goes into the preparation of this. Director Rob Galloway, who writes this problem and who has run the program here at South Texas for several years. His assistant, BK Covington, all of our IT teams and everybody who pulls this together, our Board of Advocates, Trent Cooper, and all of the other students, all of the witnesses. Thank you to all of them for all of the work that they put in to make this a great experience. I am only sorry that we can't show you Texas hospitality in person, but I hope you will give us an opportunity to do that at another time. So let me very quickly share the screen and we can begin the awards presentation. Very good, making sure I'm getting the correct one. All right, it should be on the screen right now. You should see awards presentation, yes? Very good. So first of all, we want to start with the most professional advocate. And the most professional advocate team award goes to Cumberland School of Law. And here's why. During their argument on Thursday, the team competed in a tornado. Literally, during a tornado. Sirens went off in the middle of closing arguments. They had to evacuate to a shelter where they reconnected to Zoom and in time to complete their rebuttal argument. So if you want to talk about going above and beyond and maintaining poise in a situation, let's hear it for the Cumberland School of Law. We've never given the most professional team award that I know of. Now we have for this circumstance. Congratulations to them for maintaining their poise in obviously a challenging situation. And fortunately, no one hurt, which is the most important thing. So moving on to the next is outstanding advocates. And the outstanding advocates that have been voted by the judges include the following: Ariana Bagirian from American University's Washington College of Law, Amanda Blons from the University of Houston's Law Center, Matthew Capacete from Temple University, the Beasley School of Law, Eddie Hettel from Illinois Institute of Technology, Chicago-Kent College of Law. Our own from the final round, Haley Kairab from the University of Georgia School of Law. Congratulations. From the final round again, Rocky Maas from UCLA School of Law. Congratulations. Daniel Nelson from Campbell University's Norman Adrian Wiggins School of Law. Andrea Vizcarra from St. Mary's University School of Law, just up the road in San Antonio, Texas. So congratulations to all of the outstanding advocates, including the two who participated in the final round today. Moving on to the outstanding trial briefs. University of Oklahoma's College of Law submitted one of the outstanding trial briefs. Temple University's Beasley School of Law submitted the other outstanding trial brief. And the best trial brief award goes to the University of California, Berkeley School of Law. Congratulations to UC Berkeley. Now we can move to the octa-finalist teams. The octa-finalist teams included Campbell University's Norman Adrian Wiggins School of Law, Duquesne University School of Law, Samford University's Cumberland School of Law, St. Mary's University School of Law, Southern Methodist University, the Dedman School of Law, Temple University, Beasley School of Law, UC Berkeley School of Law, and the University of Cincinnati College of Law. Making it into the quarterfinals, the quarterfinalist teams were American University, Washington College of Law, Georgia State University College of Law, Illinois University of Technology, Illinois Institute of Technology, Chicago-Kent College of Law, and Nova Southeastern University, the Shepherd Broad College of Law. Let's move on to the semifinalist teams. Howard University School of Law and the University of Houston Law Center. So now the folks on the call are very interested in the next couple of slides, so I will not delay at all. Okay, just a little delay just to make even more of a moment. All right, moving forward. The best advocate in the final round, one of the advocates from the previous rounds, Haley Kairab, University of Georgia School of Law. Congratulations, Haley. Very, very well done. Exceptional round. The finalist team, UCLA School of Law, which means that the winners today, the champions of the South Texas Moot Court Challenge for 2021, the University of Georgia School of Law. I believe I am constitutionally required to say go Dogs at this point. Congratulations to the University of Georgia School of Law. Thank you all for participating. The 11th annual South Texas Mock Trial Challenge we are announcing today, next March 23 to 27. Please mark your calendars. Our plan is we will be here in person in Houston, Texas, and we will be able to celebrate with you then. Thank you again to the guest judges who participated today, all of the former champions. Thank you as well for the individuals who participated today. Exceptional job all around. I cannot wait to hear how you continue to progress in your careers. So I believe that is all we have for today. I will turn it over to the bailiff if there's anything else before we end for today.
No, that is all. Thank you so much.
Very good. Everyone, please be safe. Thank you for participating. And from here, all of us in Texas, thank you. Take care.